ಏನು ಹೇಳಿ ಏನು ಅಪ್ರಕ್ಕೆ ಏನು ಹೇಳಿಕೆ memo
For early hearing, madam, because I have already submitted. Early date may kindly be given, because 4 months ago itself I have filed my reply statement also.
You have filed your early hearing application? Have you filed early hearing?
Yes.
Early hearing.
Yes.
Is it a fresh matter?
Fresh matter. No, it is a pending matter rather, because I have already filed the reply statement also to the appeal. Other side, I had informed the last 2 times, but today also I shall inform him the date. Please, my lord.
The lordship can't leave us. They make one sufficient.
Yes.
They make one submission.
Sir,
One tax matter, my lord. That matter was heard on 15/10/2024, my lord. Judgment reserved, my lord.
Wait for this week. What is this?
The WPA number, my lord, that is the only.
We have the number. Let's be assured.
Yes.
Yes.
Please, Lord, this is a fresh matter. No KV has been filed. I am appearing for the petitioner ESI Corporation. This petition is filed against the CAT order, which came to be dismissed, my lord. The issue in the CAT was that the stipend which was wrongly paid to the employees who opted for his PG course has sought to be recovered from the petitioner. That order came to be dismissed, my lord. That order is now under challenge. It's a fresh matter. My lord, it's a huge stipend amount which has been paid wrongly to the petitioner. More than 45 lakhs has been paid. It has to be recovered, my lords. It has been set aside. The order of recovery, the show cause notice which has been issued to the, yes, my lord.
Content filed?
Yes, my lord. No contempt has been filed. Any,
Objections clear?
yes, everything is
All
clear.
objections?
All objections are clear, my lord. Grateful.
Your lordship,
Any caveats?
No caveat.
Yes.
your lordship, habeas corpus matter, your lordship. Habeas corpus petition, your lordship. The detainee has been restrained in a de-addiction center at the instance of his brothers, your lordship. And the wife is not even given access to her husband, and that is the detainee.
Fresh petition you have filed?
Yes, your lordship.
Do you want?
Today, your lordship, there is an urgency because,
Tomorrow?
your lordship, there is an urgency, your lordship. Unnecessary medicines have been given to the detainee, your lordship.
Yeah.
Unnecessary medicines have been given to the detainee, your lordship. De-addiction center, your lordship. Much obliged.
My lord. My lord, application for early hearing has been filed. Application for early hearing has been filed.
Copy ಬೇಕಂತೆ.
Yes.
Last time I had made a submission that an out-of-station counsel is engaged from Calcutta.
Do you want?
Kindly have it tomorrow. Entire LCR is before this court since the last 1.5 years.
So, but this is early hearing, huh?
Yes, early hearing application has been moved.
You have it on 28.
28. Obliged.
My lords,
Yes.
commercial appeal, my lord, have filed an application for early hearing as well. I'm moving a memo. My lords, the appeal is filed against the order of temporary injunction granted by the commercial court. On the last date of hearing, my lords, learned senior counsels I had engaged were not able to appear. The order, your lordships, the date was given in the month of April. The urgency is that, my lords, end of the financial year, lot of subsidy amount that has to come is also stuck in the governmental departments. That, and also, my lord, some new fresh of facts based on their statement of objection that they have filed, which can actually, your lordship can dispose the matter based on that. Yes, my lords, there is a grave urgency, my lords. My lords, my entire business is stuck for the past 3 to 4 months, my lords.
What is the date?
19th of April. My lords, 1 more month, my lords, I'll suffer another.
Please, my lords. Matter for preliminary hearing, my lords. The petitioner is a retired pensioner and the monetary benefits have been stopped, my lords. He's in financial distress. Appeal, my lords. Please, my lord, single judge, my lords. 20.
The commercial appeal of the year 2024, all defects have been cured as on July of 2024 itself. The matter has still not been listed. It's for admissions. Divergent findings have been found out by the arbitral tribunal as well as the trial court. Trial court set aside my award that was handled in my favor. The urgency is that he's in illegal possession of the property that I have assigned to him. I kept moving the matter, my lord. However, it never reached before the honorable court. That's why.
What never reached?
The matter.
It was listed in the list.
It was listed, my lord, but way back in the last year only. Much obliged.
Serial number 27.
My lord, this is the both parties will be now compromise the petition, my lord. Please kindly next week may be posted, my lord. Yes, wait, my lord. The memo for posting, my lord.
Yes. All the list.
Adjournments. Page number 23, page 11, 24 to 27.
My lords, 27, my lords. This is the matter, commercial appeal, my lords, where the connected writ petition was filed regarding. My lords, we filed a commercial appeal, my lords. The commercial appeal is, my lord, listed before the roster bench, which is, my lord, Court Hall 1. My request, my lords, is to tag these appeals with that, because the contention raised in the writ petition was that the order of the trial court would be in effect modification of the orders passed in these commercial appeals. So therefore, my lords.
My lords, I appear for the appellant. My submission is that the issues in both the appeals are completely different. The order which has been challenged before this honorable court and which is listed today questions the order that was passed on the interim application for stay that was filed initially. That was held against me. Thereafter, this honorable court was pleased to grant me an order allowing me to take appropriate steps pursuant to the DTD, which I have done by issuing the invocation notices through defendant number 4, that is Axis trustee. That is the question that is before this honorable court. Among others is a question of jurisdiction as to whether the trial court had the jurisdiction, because the DTD had an exclusive jurisdiction clause and courts at Mumbai were to hear these matters. The issue that is in appeal, which has now been filed, which is posted before the Honorable Chief Justice, only pertains to the invocation notice. Now, if these appeals were to be allowed.
The submission made when these appeals were sought to be heard before this matter was sought to be heard before the trial court as well, the commercial appeal which is pending, was that it would amount to modification. Kindly see the order, my lords. Kindly see. This is a submission made by them, not by me. It's a submission made by them.
Please,
based on that submission,
that modification is only with respect to these appeals.
Based on that submission, my lords, the order of the trial court is partially based on that submission. Given that situation, that when that commercial appeal comes up, my lords, the submission that will be made there is that because these commercial appeals are pending, that has to be heard along.
No, my lords, if these appeals are allowed, then in fact the jurisdiction of the court itself is found that the trial court had no jurisdiction.
Yeah,
My lords, it's 950 crores, my lords. My lords, it's listed on Wednesday before the Honorable Chief Justice there. We're not opposing the hearing. Please, my lords, these appeals would need to be heard because of the question on jurisdiction itself. No, my lords, this will have to be heard separately because if the question of jurisdiction is found in my favor, that appeal itself goes away. My lords, these appeals question the very jurisdiction.
Going there and say that these two are different.
Please see the submission made by them. Please see the submission made by them in the order.
May I make some permission?
Please see,
In
turn over the
these
next page,
appeals,
madam.
Really, I have no role to play because in these appeals, it's between the debenture holders and the company. Debenture trustee, they have challenged the action taken by me, the debenture trustee, in the other matter. The writ petition, like I submitted, my lord, has become infructuous. Now they have challenged the recent order of the commercial court. And that's before the Chief Justice. The matter had come twice, and twice they did not say that that matter has to be tagged. I have no.
No. My lords, we made a submission.
why?
They said,
I
my
wonder
lords, we
why.
made a submission regarding the writ petition because, my lord, they made a submission, not just kindly see the, my lords, I've produced the order. They've said the learned senior counsel appearing for respondents.
Submission is being made, say that it should be heard here.
Well, I have no difficulty, my lords, this honorable court hears it. But my lords, that appeal necessarily has to be tagged with this because my difficulty is this. My rights as asserted in that appeal, my lords, directly flow from an order passed, an ad interim order passed here. So therefore, my lords, if both the matters are not heard together and a conclusive finding is not given on 4 matters together, then my lords, it will result again in complications.
Saying, you can do one thing, we record your submissions that need to be heard, and you are opposing it.
Please,
Then you will say, let this matter be also listed before court number 1.
Yes, sir.
Please, my lords. In fact, it should have been heard on the last few occasions. Time was sought on various reasons. The only difficulty is that several applications are also being filed before the trial court seeking orders for release of the pledge. Now, the question is if
What my learned friend is a third set of applications have now been filed before the commercial court, and they say these matters are pending, and these things. The multiplicity of proceedings, what my learned friend is submitting is, if the question of jurisdiction which arises in these applications is decided, then nothing survives. Even the other commercial appeal that they have filed and the applications that they have filed before the commercial court, everything goes. That's what my learned friend
They have
is
not filed an application in a 7 Rule 10. If they had filed an application in a 7 Rule 10, I would fully understand. Orders are passed under 39(1) and 2 in my favor.
Also be brought.
My lords, I have.
Got the submission, we got your submissions.
Please.
That, connection with that. How would we resolve it?
my lords, we're saying that these applications, if these appeals are heard and allowed, then that appeal need not be heard because the question of jurisdiction is what is raised in these appeals. We are saying that there is, in fact, the trial court had no jurisdiction because it's an exclusive jurisdiction.
Yes.
Please, my lords, because if this honorable court is to find... My lords, we're saying that these appeals can be heard today, and if a finding on jurisdiction is made finally in these appeals, that appeal itself will go. No question will arise because if the trial court had no jurisdiction to pass the orders, and that finding is made before this honorable court, the question goes away.
What you are saying that this also can be gone there. There is a point of jurisdiction which they have placed.
Lords, all issues can be gone into. I have no difficulty. Insofar as jurisdiction is concerned.
Then that to be heard together, both these.
My lord,
This set of.
I mean, because ultimately, my lord, all the applications arise from the same matter. Therefore, it is
Please, ma'am.
ideally it should be heard. That's why I said when the matter came up twice, this matter has come up today. The other appeal came up twice last week before the
Other appeal, my lords, other
this thing.
appeal
They
came
should
up.
have
My lord, that
ideally
is not correct, my lord. Other appeal came up. It did not reach, my lord. We tried to make a mention. My learned chief had to rise for the day. My lords couldn't make the mention.
So we'll place it there.
My lords, let our objection be recorded because our submission continues to be that if this appeal is allowed, then the question of hearing that appeal does not arise because the suit itself goes away. No, my lords. In fact, the interim order granted by this court granted me the permission to take the action that I took. So my submission remains that if the question is that court, the trial court had no jurisdiction to pass any of the orders, including the interim order, then everything goes away. The suit, the commercial appeal, the writ petition all fall away. by virtue of the fact that the trial court had no jurisdiction to hear the matter and pass orders in the first place. Now, while a 7 Rule 10 has admittedly not been filed, the very contention taken in the objections to the 39(1) and 2 is that the court had no jurisdiction. Now, the question of jurisdiction has been decided by the court only on the basis of fact communications were received by the plaintiff in Bangalore, whereas there is an exclusive jurisdiction clause, and the only party who's not a party to the DTD also has its registered office in Bombay. So our submission is that the entire cause of action arises in Bombay. There is an exclusive jurisdiction clause. Therefore, in those circumstances, if these appeals come to be allowed with a finding that there was no jurisdiction, everything falls away.
May I make one suggestion? My lords may record submissions of both the counsels that these two matters are here and two matters are there. My lords may place it for orders before the learned Chief Justice. Let him decide, my lord, which matters have to be tagged with what.
Please.
And my only submission is let the matter be posted on Wednesday, because the other matter is also on Wednesday. Let some.
My lords, respondent number 1 to 4 minutes.
Four states that two appeals.
3, my lords, 3. Only
One
one
appeal.
appeal. Only one.
One appeal and one writ petition. Writ
Yes,
petition
my lord.
number also.
My lord, it's commercial appeal 148 of 2025 minutes.
For the bench decided by the Honorable Chief Justice, these appeals we also listed along with that appeal. That's right. This submission is contested by the learned counsel appearing for the
Appellants in all 3 matters.
appellants in all these appeals, stating that the present, stating that the appellants have challenged the jurisdiction of this court
Please, ma'am.
for entertaining the present appeal.
Please, ma'am.
Hence, in that sense, both are not connected. These appeals are not connected with the appeal listed before the court. The complaint shall be
Instead of saying not connected, they can be independently decided is the right way of putting it.
She submits, these appeals can independently be decided. We hold the pendency of the appeal before the bench of the Honorable Chief Justice. Complaint shall be, in view of the submissions made, we deem it appropriate to this appeal before the
For directions before the Honorable Chief Justice. Whether those matters have to be tagged or whether these have to be tagged, like administrative side, like directions we pass instead of posting it, connecting or posting it with those matters. The difficulty is this. I mean, we have some practical difficulty. I'm sure my learned friend also. If whether the matters will reach there is a big.
No, that's a different.
I mean, off the record, that's.
This state is right, or we say place it before the bench.
Minister,
From the submissions made, these appeals be listed before the bench decided by. Totally.
On the administrative side is better, my lord, whether which has to be tagged with what, because of this division of years, this.
Which
issue
would
has
become the
arisen
main
because
appeal. I think the
20
submission
to
is
24 my lords have
The
the roster. So from 25, the chief, Honorable Chief has the roster.
Or the operate would be to make, you will make a submission before the Honorable Chief Justice, that if the appeals are there, those need to be open.
That's exactly what I said last week. They should have.
19 morning, I'll seek instructions. I'll try and make.
Not say anything.
Please, Manoj.
Yes.
Okay, operate would be that, then make a submission there, that was also pending. Please.
Because these are first in line. These appeals are the first in line.
But the difficulty is this. Honorable Chief Justice asked, have you mentioned in that court, because the matter did not reach there on the last occasion. Mentioned in that court or not was the, then it will become a problem for me. But Honorable Chiefs were to, please. No,
I don't think they have not even attempted making a mention.
Lord, I could not make a mention at 10:30 in the morning for a matter which is listed at serial number 79. Matter reached up to serial number 64, my lords. We were waiting in court.
Tell them what to do.
My lords, whatever, my lords, may please record.
My lords may post these matters on Wednesday before the other matters are on Wednesday before.
My lord, yes, but the difficulty is this, my lord. I am pressing for relief in those other matters.
Not understanding, we want what, if it has no difficulty, send it there. We are only saying that you would mention it there and so that these matter can also be called before the Honorable Chief Justice.
My lord, no, my lords, my request is please place it on the administrative side for the Honorable Chief Justice to take a call on which should be the main matter. Whether these matters should be considered as the main matter, should that matter be considered as the main matter?
Then he has to hear the parties. Taking up by.
My lords, then
Submission is contrary to what the party in the sentence, we say no need to be heard here.
I have no difficulty either here.
No, not to be heard here. I don't think that's what my learned
He
friend.
said independently.
Independent.
This can be heard independently because the question of jurisdiction arises in these matters, not necessarily in those matters.
Consistency is required of the council. Taking a call also.
No, therefore, what your lordships have dictated, only thing is whether it has to be placed on the administrative side or to be is what my lords have to decide.
Yes.
My lords have noted the submissions.
My lords may just place it on the administrative side, that as learned.
If not, so practice state that who will make the assistance, who will give the assistance? Who will be the assistant?
So
Let these matters be on Wednesday, my lord. We will between us, we will see whether to mention before that.
Stay there.
Here
This,
it's-
this honorable court, my lord.
Let the matters be posted on.
Say.
my difficulty, my lords, is on 19th when I press for relief in that commercial appeal, my lords, then it should not. But if I have to mention, no, how, my lords, the difficulty is that, my lords, let me just put my predicament, my lords. My predicament is, my lord, there is some kind of an oral understanding, my lord, which is being honored till date.
No, I am not sticking to that oral understanding
So-
anymore because that was your lordship asked me whether we are doing anything until they file anything as of.
Now, the difficulty is
don't
when the matter comes up on the 19th, when the matter does come up on the 19th, my lords, I should not be put in a position where they say, no, this amounts to modification, because that is a submission which is made, that is a submission which is recorded. Then again, my lords, then the Honorable Chief Justice has to post that matter which is on 19th to a subsequent date, and then it just whole process will get delayed. That is the apprehension.
This and we said that we listed.
No, that is what perhaps,
That's
therefore I'm saying, my lord. My lords had asked me whether we are doing, as far as the debenture trustee is concerned, your lordships asked me whether we are going to do anything until they file an appeal against that order in the other matter. Now, they are harping on that. Now, that understanding, I am making a statement today that now that they have filed that appeal, I cannot be bound by that statement tomorrow. That's all I am saying, because their strategy is that tag along these matters with that, they will never reach, and my understanding, my statement stands.
no,
That is-
my lords, with
that
great
appears to
respect,
be
that
appears
is
to-
not, that.
They are only concerned with the submission, what we made and what we have did.
Yes.
If you want, then you can argue there also, we adjourn this, you can argue there also about these matters need to be heard for, whatever it's worth.
Please place it before court hall.
Please, please.
We just add that, we said, sure.
Interim order needs to be extended.
On the ground of jurisdiction of.
Please. Of the trial court, my lord, the commercial court,
Jurisdiction of the trial.
please.
Pay the suit.
Please, my lord,
Pay the suit.
and to pass orders on the interim applications.
Pay the suit.
Please, my lord.
Pay this. And as such, this appeal need to be heard first.
Please, my lord.
And in the point of jurisdiction is not held.
ಇದನ್ನ ಮೇನ್ ಅಪೀಲ್ ಮಾಡಿದ್ರೆ ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ. It will be in the top of the board.
Not be heard.
Please.
This submission,
Please, my lord, would fall away.
update shall be, these appeals are listed before the court number. In view of the submissions made, we need to appropriate to this appeal before court number.
Interim
On
order.
19.
Please, my lord.
My lords have to tag the,
We are
Long
not
with-
saying so.
very,
We are
I
not
follow.
saying so. We are only placing it.
Please.
For the court, because all the matters would be before the court. Court will hear you on that. See the point?
Please, my lord, the interim,
Serial number
Serial number
26, 23, my lord.
Sorry, early in the morning, we took so much of your time.
Yes.
Serial number 23, my lord. Representing on behalf of the Surana, my lord. Please, representing on behalf of the respondent Surana, Council, my lord. He is inconvenienced today, my lord. I have done next week.
Next week we take. The appellant.
Respondent, my lord. Appellant Kalyan Basuraj, I informed the other side, my lord.
I'm for the appellant's counsel. We have been informed, but I just want to make a mention that we've returned the file already. I'm not sure if there's someone else who will come on record.
The appellant, serial
done.
number 23.
Yes.
We have challenged the interest. We challenged the interest in this matter.
Yes.
Disseminate Act, Section 16. Non-pending case.
Seeking an adjournment.
Next week.
Next
Yes,
week,
yes, please, my lord, because it's been pending from a very long time.
next week only,
Very long time, my lord.
please.
Last
Priority is ours. Okay, take it off.
last week as well, they didn't appear, my lord.
Next week, any date, my lord, please.
Hospital. Not next week.
Any date, my lord.
Yes, say that in the request of counsel.
Respondent, my lord.
Respondent.
26th, my lord.
In April. Yes.
Serial number 24, my lord. Serial number 24 and 24.1, I am representing for the appellant, my lord. I sought for 1 week time to personal inconvenience to my colleague. I informed other side advocate. Appellant, my lord.
Yes.
No.
17-6.
In serial number 26, my lord. Yes. I am appearing for the first respondent, my lord. The appellant has not deposited the 50% of the award amount, my lord.
26.
26, sir.
You can just wait.
Please.
See that.
My lord, serial number 36, my lord.
Yes.
I am appellant, 14%. I will file this synopsis, my lord. Time may be given.
You're fine.
I will file synopsis, sir. Time may-
Who is the other side?
Other side is Mr.
Deep South.
Pradeep Pradip. I will inform you.
Just inform me, let the matter be called. You call the matter. Next.
My lord, serial number 28, my lord.
Yes.
I'm in this case for the appellant, my lord. I've informed the respondent counsel, my lord. I seek for a time. Senior is unwell in this case, my lord.
17-6.
Please, my lord.
My lord, serial number 43, my lord. It's a connected matter. 43, my lord, in the appellant number 1 is died on 7th March, my lord. The legal heiress is already on the record. I will file necessary memo along with the death certificate of appellant number 1. A week's time maybe.
On the other side.
Yes, my lord, I already informed the other side. Yes, in 43. Yes, my lord.
Eighteen six.
My lord, serial number 45, my lord, for the respondent. A week's time may be given, my lord. We have informed the appellant side regarding that due to a personal inconvenience, my lord. 45, my lord. Respondent, my lord.
Eighteen six.
Obliged.
My lords, with your lordship's kind permission, I want to move a early hearing application, my lords. This is a pending commercial appeal. The urgency is that these are arbitral proceedings on which there is a stay basis or granted by this honorable court for a arbitration which has been pending since 2014, my lords. There was 2 rounds of arbitration. Now, my lords, it's at a stage where the dissolution of the partnership firm is effectively pending and there are assets which cannot be dissolved properly and distributed because of the stay, my lords. We've already filed an early hearing application, served it on the other side. I'm seeking a. My lords, there's a, just a submission, so there's a date already given, my lords. It's on the 16th of April. On the 16th of April, my lords. If any sort of earlier date is possible, my lords.
To be present. Serial number 1, Shri Jayasimha. Serial number 1.
Petition, my lordship.
What are your instructions?
Lord, he is before the court.
The son has come.
Yes,
He is the son.
yes.
Where is the petitioner?
Petitioner is unable to come because he is suffering some disease, my lord.
Then what is the difficulty? Where was he?
He on his own volition went, Lord.
I know he went to Tamil Nadu.
Yes.
Was there any internal issue?
Nothing, the information is that he had borrowed loans and therefore.
He had?
Borrowed loans, money,
Huh.
therefore
He left the place.
he left the place and is back now.
Now what does he want to do? What is his age?
He is 27.
He's 27. He wants to go back to the family.
It is his choice, but he says he doesn't want to go to his parents.
He's went to his uncle's house.
You know, he's a grown-up
Because-
man almost. He has his own choice now.
Because his behavior is not good, my lordship. He's brought some money from the house. There is a dispute between the parents and his him.
Right. But can you now force him to go? Can the parents say, come back to home? He said, no, I will not. What will you do?
Left to him, my lordship.
That's right. That's what he's saying.
Yes, obliged, my lordship.
So what shall we do? Infructuous, now his presence is there before us. Now, but the only thing is, although, what is, just ask, what is his name?
Because his parents is absent today, he is not able to come. His parent is not come, the petitioner is not come. So
It appears his father is here in the court.
Is he? Just ask him, he is the son.
He's went to his auntie's house.
That's right. He is the son, huh?
Yes, my lordship.
Just explain him now. He says he doesn't want to be there. Explain him.
ಬಿಟ್ಬಿಡೋದ ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಬಿಡೋದು He's okay with him going to his aunt's house.
He's fine, huh?
Yes, my lordship.
Just say that. Then you will withdraw this.
Yes.
Yes, my
That's
lordship.
the,
This petition challenges. This petition has been filed with the following prayers. The case of the petitioner says that their son has been missing since 14/2/2025. Mr. Beliapal under SPP has we find that the son, namely, what is his name?
Akshay Kumar.
Akshay Kumar.
Akshay Kumar is present in the court. We have been also informed that his age is 22 years old, 22 years. Full stop. Akshay Kumar states that he intends to go to his house, his aunt's house. At which place?
Hiriyuru, my lordship. Hiriyuru. Chitradurga district.
Just noted that. Full stop. The petitioner number 1, father has no objection if Akshay Kumar goes to his aunt's house. The counsel for the petitioner states that in view of the fact that the son has appeared in the court and he intends to go to his aunt's house, the petition be closed, ordered accordingly. Okay?
Obliged.
Thank you.
Serial number 2, Sheshabri. Serial number 2.
Objections be cleared within 6 weeks.
24-6, serial number 3, Shiv Kumar.
Applying, my lord, in 3.2.
Yes,
Lord, may I submit this, my lord? There's one more matter, my lord, writ appeal 20 of 2025. My lord, that is coming on 19th, my lord, before Court Hall 1. My lord, all these matters may be tagged along with
that.
My lord.
I may only make this submission. This is the matter, lords, where the finding of the learned single judge is that the society has encroached about 5 acres of land after the learned single judge got a report from the additional director of land records. The direction is to, lords, secure back the possession to these poor farmers, lords, whose lands have been deprived. This is the 9th time, lord, the non-compliance of office objection is coming up. 8th time. 10th times. But you let them at least comply, my lords, or offing us hanging. And there is an interim order, my lords, working against us. Therefore, my lords, we are at that position. I leave it to your lordships, sir.
My lord, the office objection, my lord, in the first matter, I guess it's only a non-filing of submissions. In the second matter, my lord, it's only an impleading application as filed. Then in that office objection, my lord, in the main matters, my lord, all the office objections have been cleared.
See, wherever there are office objection, you need to remove it.
Will that do?
Just say that learner counsel for the party states that a connected appeal arising from the same impugned order, na?
Same impugned order.
Arising from the same impugned order being appeal number
Writ appeal 20 of 2025, my lord.
20 of 2025 is listed before the bench presided by the Honorable the Chief Justice on
19th, my lord.
19th of March 2025. They request that this appeal be also listed. These appeals be listed along with the said appeal.
Please.
It is ordered accordingly on 19/3/2025.
In the meanwhile, let them comply with the
In
appeal.
the meantime, any objections in the writ appeal shall be complied with before the, just say that the objections in the appeals be complied with before the next date of it. Interim order, if any, to continue. No, is this on our board? 3.8? No, then you make a request there. It's not on our board.
Please,
Make a request before the Honorable the Chief Justice. Next.
grateful.
Serial number 4.
Here for the respondent mother, my lords, there was a report sent to be prepared by NIMHANS. I believe the
We got the
NIMHANS,
report. We
My
have
lord-
not seen it. We
my
got
lords,
the
even
report.
we have not seen it. May I request if a copy can be made available just to
Please.
the
I
councils,
would be obliged.
can be taken tomorrow.
Just tell us why this report was called.
The reason the report was called, my lords, the reason the report
this
was
report.
called is, my lords, we pointed out
Not from-
after the My lords, after the habeas corpus petition was filed, the respondent mother, we pointed out that in fact, even in the orders, there were orders passed by the court in the United States, wherein they have rejected custody to the father. Custody has been given to the mother. And in that order, it's a detailed order, there are findings that based on the counselor's interaction with the minor girl who's around 7 years old, there were in fact serious allegations of sexual abuse. And though there was no criminal complaint or anything filed, the counselor's interaction was taken as evidence before the proceedings in the US court. And when this was in fact pointed out, this honorable court said, let there be a, let the child be taken to NIMHANS. In fact,
Was a-
we have also not seen it.
There was another report also, my lord, which was totally outside purview, saying that there was no, the allegations, what is stated by the earlier counselor was not
He has
correct. So
filed-
that is the reason why the court said, let us have a neutral report from NIMHANS.
Decide for the next meeting. If a copy could be,
Just see what is the prayer here in this.
in fact, the prayer
Custody.
is to,
Basically to produce the ward, the child to be produced, that is the prayer.
we have filed guardianship proceedings. He is free to ask for visitation. There are no contact orders by the US court against him. Custody is given to me in the US. There are no contact orders on him. I have filed now a guardianship petition. What survives, my lords? He is free to make an application in the GNWC case here. If he makes out a case despite all these findings.
Now, tell us one thing.
Please.
What are the proceedings here? In India?
There are GNWC proceedings, there are,
Guardianship.
Yes,
that is filed by the wife.
yes.
And this is an independent writ petition filed without challenging any order of the guardianship court?
No, my lord, it's not challenging the orders.
Just an independent.
It's an
petition.
independent petition filed saying that the child is a citizen of US and there are custody matters pending before the California court as well.
We have also filed other petitions before, we have filed writ petitions here.
There are several proceedings which were the subject matter before the Californian courts, my lords, which were part of writ petition filed. Subsequently, the child was brought to India.
See, we have seen the report.
Please,
So,
My lords, there are
You have
orders
a
when guardianship and
copy?
custody proceedings are pending and the child is here. And where is the locus of any habeas corpus? He has to go and contest it. In fact, there are orders of also the
Yes,
Supreme Court and our
if
High
my
Court.
lord
my
gives
lord.
me some time, I will.
see,
commit-
otherwise appropriately is that, when the guardianship proceedings are pending, you'll work it out before the court.
My lord, I have raised the objection of jurisdiction there, saying that.
Whatever may be.
Yes, he can.
I cannot understand. Those are on the proceedings, na?
Please, that those on the merits, my lord, saying that since the child is a US citizen, guardianship, GNWC in India is not maintainable. Already the custody proceedings is pending. before-
Possibly you may succeed. Possibly you may succeed.
But
The court
that will
below
end in
may
a
accept your
dismissal.
plea.
If it ends in dismissal, then.
Today it's only pending hearing there, everything. You have sought the custody in these proceedings. That's right. We don't want to say anything, whether the same will imply for you also.
I get,
Getting the point?
only thing
Is
is,
a
my
report
lord,
something,
if my
which,
lord,
you want a copy of all both
Please,
of you?
If
Please,
we can
madam.
get it.
so that main submissions we can make on merits also, I would.
In
make a
fact, can I
submission.
just hand over one judgment of the Supreme Court,
On what, for what
which
purpose?
says that the remedy lies before the family court in the guardianship matters.
You will work it out there. That's not the issue here.
Yes,
See, there are certain things here in the report. Don't want to disclose, otherwise you will see yourself.
Please,
And possibly we will ask you, you apply for a certified copy and then
We'll do that.
only both of you will get,
exactly. It
Please.
should not be made public.
no one else.
Yes,
very
we'll
well.
apply for that.
Or we can say only this. We can say that only you as a counsel, the whosoever a counsel or advocate on record will get it and it remains in the sealed cover.
Please, please. Very well. I oblige.
If we apply for certified copy, it will therefore be made public. So instead of that, it can just be handed over to the councils on record and it can be remaining in a
What we will
sealed
see.
cover.
Please.
Oh, these copies are-
We'll do one thing. We will not say anything. And possibly we will just call one of the doctors who had and just ask him whether we can give the report to both of you. Obviously, you may intend to use it for the future proceedings also. Please. And you must know what is the position that
What
has
is
been
the
narrated.
finding? Yes.
That has been narrated in this, because ultimately this is in the larger interest of the
Child.
child. So
if I can just submit, just my suggestion to my lords. My lords may certainly speak to the doctor concerned, but the doctor may then certainly defer it to my lords. And even in these cases, the parents, the child is with the mother. And therefore, it is important that at least the mother knows whether, and then it can remain in a sealed cover so that it's not made public to any third party. Just on directions of my lords, just the court officer can hand it to the two counsels on record, so that it is and the original can remain in a sealed cover.
Let's see that where was the order passed? The order passed by this court seeking the report of the.
It's dated 1712, my lords. It does not make any mention.
Doesn't say so. Huh?
No, 1712 order. It says heard learned counsel appearing on either side, as well as Shri so-and-so learned HCGP. We have also interacted with petitioner, respondent mother and minor child, having considered the contentions advanced and the allegations raised by the mother respondent against the father petitioner. We are of the opinion that parties require a full and proper psychological evaluation to identify whether there could be any basis for the allegations raised by the mother. And thereafter, parties were referred to NIMHANS for a full proper evaluation. They will mark their appearance. Director shall peruse this order and make necessary arrangements for a detailed examination of the petitioner, the child, and the mother by appropriate personnel. Report.
We can do this. We'll ensure it is sealed now before us.
Yes.
We will fix a date and time before the Registrar Judicial. We will only allow you to read it. We will not allow this.
To take copies. Very well.
Take copies.
Very well.
And it would be sealed, resealed again there only, there and then. This we are only saying that possibly you should know what is the evaluation of the doctors.
True.
And this would remain put it in the seal cover.
Very well.
Okay, so that at least you will have what is the opinion formed. Opinion form both of you.
Please.
And it will continue to remain in a seal cover.
Very well.
We leave it to my lords. No, my lords may do that. My submission is with those directions, this petition be closed.
This would, and be very frank.
Yes.
On two aspects.
Please.
So the first aspect is when their guardianship is pending, this in any case is not.
My lord, in that, my lord, I would like to make submissions on the main matter, my lord. If my lords could fix a date, I will completely argue. I leave it to my lord's jurisdiction.
Just say this. In terms of order dated 17/12/2024, and also 24, the director NIMHANS has produced the report submitted by the report pursuant to an examination of the petitioner, the child, and the mother. Video communication dated 3/3/2025. The same was in a seal cover. The seal cover has been opened by the court officer. Full stop. We have perused the report. Full stop. Get a cover and seal. The same has been perused. The same has again been resealed. Just put it in. Okay. Full stop. The learner counsel for the parties have expressed that they should be permitted to see the report. Appropriate shall be that the counsels shall appear before the Registrar Judicial on day after tomorrow. At what time convenient?
Whatever time.
Afternoon,
1:30,
afternoon session.
anytime.
You tell us time.
Afternoon session would be.
Okay, at around 3:30 PM.
Please.
When the Registrar Judicial shall reseal the cover and allow the councils to only peruse the report as submitted by NIMHANS in no way, at no cost. The report, the physical copy of the registered judicial shall not make a copy of the report and it is made clear that the counsel for the party shall not be entitled to a copy of the said report. Full stop. The registered judicial, after the councils have perused the same, the registered judicial again reseal the report and report till further orders of the court. Very good. Till further of the orders of the court. Bus. Okay.
Please.
Yes.
And then we will have this petition next week.
Very well.
And we will
My lords,
see
may I in fact submit that in light of my lords' observations, which my lords are well aware.
the last one.
Nothing to do with the report. Report, we have no objections, my lords. But the fact that GNWC proceedings are already pending, nothing further remains, my lords.
My lord, I would like to make my submissions, my
See,
lord.
to be very frank,
Subject, I know, my lords,
the very indication that we have doing such, you must have got an indication.
I know, my lord, I
Don't want to spell it out.
will make my submissions to whatever limits I have after going through the report as well. I could make my few submissions and I will be obliged to whatever orders my lords are. I will
See,
not,
we will have it, Pranay, so that you can have an opportunity to look into it.
please.
We don't want to make it, interdict the proceedings now. Have a look and then possibly you will take a call.
Please, very well.
Okay, just have it next week.
My lords may keep it on 26th or 28th next week.
28th would be.
28th is fine.
Just say that. We seal it.
It's 28th,
Court and court shall continue to be in the seal cover.
yes. Is-
Continue to be in the seal cover.
If,
Cannot be opened without the permission of the court. Just say that.
If 28th is a holiday,
Not all.
not a holiday,
not
very well. 28th,
RH.
okay.
Only request, only the council must see it,
Yes,
Please,
no one else.
very well.
Okay,
28th, my lords.
Thank you.
Great.
Grateful. Lucky.
Number 5. Petition is present. The missing person is also found. He is also present before this honorable court.
So this also. What is his name?
Manoj Kumar S. Milods.
Where did he go?
Milods, in fact, Milods, he was working with the respondent number 4 and 5, Milods. They are the employer. They had borrowed through him a huge sum of money. Because of the pressure of lenders, he says
The employer bought it.
he had the loans were taken through him by the employer.
And the person who
have-
has given the loan, they were after him.
They were after him, Milods.
So what
So-
does he want now?
He says he had been to the native place of his owner, where they said that they will sign some agreement. Ultimately, they have not signed anything and he could not contact them. Therefore, Milods, he was with his friend trying to arrange for the money. The petition may be closed, Milods, since he has been found.
Just say that, what is his name? Just ask the name.
Yes, Manoj Kumar.
S. Manoj Kumar,
Yes.
stated to be the son of the petitioner, has appeared before us today. Who will identify him?
His mother is
Just
there.
ask her, is he the Manoj Kumar?
Yes.
Huh?
He's my son.
As identified by the petitioner also. Full stop. The counsel for the petitioner states, since the son of the petitioner has appeared in the proceedings, the petition be closed.
Please.
It's ordered accordingly.
Serial number 6, Sri Dalwai Venkatesh.
Appealing for the appellant in this case, please, my lord. Lord, the respondent number one, please, my lord. They have shutting down their entire business. They are not. They have completely shut down their business. They are not. They are not.
Done.
Not
What do you say?
the respondent number one, my lord. The notice has issued against them.
Yes.
To the respondent, my lord, it is a corporate office, my lord. They have completely shut down their business. They are not.
So
I'll
what
take
will-
alternative steps, my lord, by way of substitute service. please,
No.
my lord.
You first take steps whether you have the fresh address, any new address. Find out.
Please, my lord, weak accommodation may be granted. Please.
Just say that you did not even take the summons, the notice also.
I'll-
What is
I'll
the
take-
report, ma'am? At least you should make a attempt, no?
Please, my lord.
Is the report. Just say, let a fresh notice be issued
Please.
for service on the respondent number one, returnable on.
836.
Much of.
7. Shri Sunil.
Appearing for the appellant, my lords, will take necessary steps. 2 weeks accommodation may be
Notice
granted.
be issued to respondent returnable on.
836.
Respondents.
Number 8.
Well, it's for the appellants in this case, my lords. As I filed a memo in regular filing, my lords, I was not able to file in through e-filing. I filed it through the regular filing counter, my lords. This is in regard to the respondent number 5 has been, she was a claimant number 3 in the suit, my lords. During the said time, she was a minor. Now she has individually filed a suit against the very appellants here in claiming partition of the property, my lords. And thereby she has been made as respondent number 5 in this case.
Yes, what do you say?
My lords, I filed a memo in the regular filing, my lords. The respondent number 5 here in my lords was a claimant number 3 in the trial court. She was a claimant in the trial court, my lords. Now, during the said time, she was a minor. Now she has attained majority and filed a partition suit against the very appellant here in my lords. She is not cooperating with the appellant, so she was made as a respondent number 5 in this case, my lords. Her name is Yashaswini, my lords. The respondent number 5 in this. Please, my lords. Against the appellant here in my lords. I appear for the appellants here, my lords. My lords, the award partially confirmed by the arbitrator, my lords, that my lords, this in regard to a joint development agreement with the respondents, my lords. Yes, my lords. My lords, that is R124, my lords. Please, my lords. Yes, my lords, it was partially allowed, my lords, and in regard to prayer E and F, it was confirmed. The other thing is that, my lords, the respondent number 1 to 4 has also preferred an appeal in 8559 of 22, my lords. The respondent number 1 to 4, they also filed, my lords. The said appeal has been admitted, and this needs to be connected with the said matter as well, my lords. 8559 of 22, my lords. MFA 8559. Lords. My lords, no supposition, my lords. There's no date fixed. I'm appealing for the, my lords, BN Jaidava. There in that suit, all in that appeal also, I have to pay for the respondent. For the yes, my lords. In 8559, I appeal for the respondent. My lords. 4 and 2, 4 and 5. Two, 4 and 5, my lords. Renuka, Industry and Nityashri, my lords. In 8559 of 22.
Any date to this 8559?
No, my lords, there's no date.
If you know that, pay 8559.
BN Jaidava, my lords, that is what it's.
Who have filed that, appeal?
Yes, my lords, it is BN Jaideva. BN Jaideva is the appellant, that is the counsel appearing on behalf of them, my lord. In that case, I'm for 2, 4 and 5.
The appellant.
The appellant is Pratap Kumar, Girish and Shufiullah. Girish Kumar,
The counsel for them.
Jaideva, my lords. BN Jaideva.
Counsel.
He is the counsel. Yes, my lords. Notice has been issued. I've filed a wakalat in regard to that.
Okay.
Yes.
8559.
Yes, my lords. 8559 of 22.
Six. Serial number 9, Ajay Kumar, 9.
Here for the impleading applicants in
Hearing for the
1 of 24 and 2 of 24. In 2 of 24, there is an office objection made out in regard to the ranking of the parties. A week time may be granted so that time rectify it and matter may be heard and disposed of. Short question is involved. With regard to
What are the people who are seeking in
the subsequent purchase from the allottees. They are not made as the party before the learned single judge. Behind their back, this order came to pass that is charging the legal.
You have filed the application for them?
I filed the application for the subsequent purchaser who was purchased from the allottees allotted by BBA. 2 of 20. Week time is only the ranking of the parties, so that the short question.
Short accommodation may be given.
Heard and disposed of. 86.
Mm-hmm. 36.
36.
Serial number 10, Shri Chadahma.
I appear for respondent number 1, 2, 3 in this case.
I appear for respondent number 5 and 8, my lord. My lord, there is some confusion with regard to filing of the wakalat. Respondent number 5 and 8 had undertaken to file wakalat for respondent number 5 and writ appeal 590 and respondent number 5 Respondent number 8 in 569, my lord. I pray for a short accommodation to verify and file wakalat on behalf of respondent number 5 and 8. I have been instructed by my colleague that wakalat has been filed, my lord. I will file it today itself. Please, my lord. I'll file it today itself, my lord.
I had to produce some documents while filing.
Lord, if he is arguing on merit, my lord, where?
No.
Matter
the
went up to
document-
the Supreme Court. Supreme
The-
Court has directed, my lord,
May I make a submission? ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಸರ್.
ಎರಡು ಬೇರೆ ಬೇರೆ. Memo documents.
Yes.
Please, the documents which are part of writ petition by oversight has not placed before. Have you permitted to place the document? I'll file it in the registry. Kindly direct the registry to allow me to please.
only memo has been given, the
No.
document which they are relying. They have
No,
not-
I'll give fresh appeal also. Fresh appeal copy also. After inserting the documents, I'll give fresh appeal. No.
He's applying reservation. I don't know why.
This is, I have given memo. After insertion of the document in the court file, I'll give full set of documents to them also. I don't take me, please.
For state,
Hey,
it's not
now-
allowed on state.
I
That's-
appear
that's-
for the state notice. Sorry, that there is some confusion in the lord. Your lordship may direct the registry to. It's
19-6,
I may permit, please, minute.
yeah.
number 11, Dilip. 11.
Lord, I may be permitted to submit on behalf of appellant's advocate, my lord. Lord, one office objection is to attest the true copy, which we will do during the day, my lord. Lord, this IA 1 of 24, my lord, is that during the pendency of the writ petition, under the protection of interim orders, students were admitted, and we had complied with the direction of the learned single judge in terms of filing affidavits, etc. And if my lord is pleased to see page 46 of the interim application at para 42 of the impugned order, para 42, it starts with the petitioner, apart from seeking granting of permission, so and so,
Then it says, by virtue of an interim order, the petitioner college was permitted to go ahead with the admission. However, the petitioner college was directed to inform and let know all the students that their admission will be subject to the final outcome of the writ petition. And the petitioner college was directed to submit affidavit through its principal stating that the conditions imposed by this court having been known to the students. On the basis of this interim order, the students have continued the course in the petitioner college. However, paragraph 42, my lord, of the impugned order, which said, yes, my lord, of the impugned order. It starts, they have been admitted even by the impugned order, even though there's the aspect of imposing a penalty on us, the students are protected. The present application is, my lord, since they have taken part in the exam, pursuant to the interim orders, we are requesting that the fourth respondent be directed to issue the completion certificate, marks card, and provisional degree certificate for those students. Because we were the petitioners before the learned single judge. That's the request to the fourth respondent. My lord, we had challenged the permission being denied. We had applied for permission on a year-to-year basis. For these, my lord, subsequent years, we have been granted permission. Yes, yes, yes. I'll place a memo, my lord, for my lords. All this 18, 19, and 20, 3 years we were denied. But under the protection of the interim orders of this honorable court, we were permitted to admit students. By the impugned order, the students were permitted to take part in the exams and in the college. Subsequent years, my lord, we have been granted permission, conditional permission.
Submit this, your lordship. The writ appeals are at a stage of final hearing. In fact, in November 2023 itself, the second respondent commission.
My lord, we are also ready to.
I beg your pardon? We have, so far as the students' rights are concerned, we are not coming in the way. But that said, that was under the judgment of the learned single judge, which is under challenge in the present writ appeals. And the writ appeals can itself be finally heard and disposed of.
We are also ready.
The question of penalty of 25 lakhs per case still remains to be paid by them. They've deposited a part of the amount before this honorable court. There are 3 connected matters. For 3 years, they were denied permission to admit students because of infrastructural deficiencies. I would object to any interim relief being granted at this stage for the simple reason that the writ appeals will continue to languish if that were to
No,
be
we are
done.
ready, my lord, to argue on the main, on any date.
Be fixed, or even if it is today, I'm ready. For those particular years, yes, your lordship. But the fact remains, lack of teaching staff, lack of facilities, and all of those reasons. And now that they have gone ahead and admitted students, the Honorable Supreme Court had made it clear whether those admissions are pursuant to High Court orders or whether the institution has gone ahead and admitted students directly. It's inconsequential. The term used by the Honorable Supreme Court is adventurous litigation. And in all such cases, severe penalties have been imposed. Now, without paying those penalties, the college is before your lordship. And today, if this interim relief were granted, then for the institution, nothing else remains because they've gone ahead, admitted students, collected fees, and stopped payment of penalty. Yes, nothing. The students have been protected by virtue of the judgment. Yes. Yes, your lordship. Because then only the merits of whether they want to continue with the writ appeal or not would be remaining. Nothing survives. Nothing survives.
They got the admission.
Yes.
It's not their case or not. You can argue that they should be the admissions and they that or Despite there being no permission.
Yes.
They should not be allowed.
Yes.
From the strength of the court order, they were given the admission. The students.
Yes.
What do you say, Mr. Ajay, on the penalties?
My lord, we have, in compliance with the order of this honorable court on 26/9/23, we have deposited 50%. My lord. My lord, the Indian Medicine Central Council Act of 1970. It was in force till, I think, around June 2021. What the learned single judge accepts the submission of my learned friend to saying that the new law, that is the National Commission for Indian System of Medicine Act applies, which most respectfully, I would say otherwise, that the Indian Medicine Central Council Act applies. Now, the learned single judge would say that the new act applies and recognize that there is a penalty provision under the authority under the National Commission for Indian Medical System of Medicine and still impose a penalty on me. My lord, when the learned single judge would say that it's like double jeopardy, my lord. I cannot be penalized by the learned single judge on a penalty of 25 lakhs and still be directed to be subject to the orders of the National Commission for Indian System of Medicine. It can't be both, my lord. My lord, because either the court would say that it has jurisdiction to address the issue under the Indian Medicine Central. My lord, that my submission is that, most respectfully, that the learned single judge says that this facility was not there. But once it says that the new act applies and therefore the competent authority is elsewhere, then the learned single judge would not have jurisdiction. Yes, my lord.
66, my lords.
It's at page 64, para 64. That would not be, most respectfully, not right, because when I was denied permission, I came before my lords. My lords granted me permission. They did not even file an application to vacate the stay during the pendency of the proceeding, even though they participated. Therefore, there would not be illegality. I did apply. This honorable court was pleased to grant, and I would submit, my lord, some orders, even if they are of interim nature, would take the color of a final order, because the interim orders, my lord, I just filed a memo, my lord, for the subsequent years. Just now. Those years, no, my lord. Only those 3 years, we were not granted permission. But if I may, no, my lord. With the direction, permission granted by this honorable court. This honorable court, therefore, I'm submitting, my lord. What has happened is the learned single judge, my lord, and if my lord is pleased to see, para 43 of the impugned order. Yes, yes.
Is the date of the
31/10/2019.
31/10/2019, my lord. My lord, in the case of writ petition 3899, covered in writ appeal 1009 of 2023, the rejection, my lord, was on 16/2/21. Then we filed the writ petition on 18/2/21, and on 25/2/21, we were permitted to admit students. My lord, this was for the year 2021, madam. Yes, madam. 3 years. This is for 3 years, madam. This is for one of the, there were 3. Yes, madam.
18, 19, 19, 18, 19, 21.
18, 19,
19,
19, 20,
2021.
2021. No, that is for that year of 2021. For the year 2018, my lord, rejection was on 10/10/2018. That is covered under writ petition 47281 of 2018, 10/10/2018. Then we filed the writ petition on 15/10/2018. And on 31/10/2018, we were granted permission. 31/10/2018. That is for the first writ petition. So that covers for the year 18-19. And for the writ petition of 19-20, that is writ petition 36606. Yes, my lord. Yes, ma'am. Yes, ma'am. My lord, the reasoning starts at my lord, please kindly observe that the order of the learned single judge is passed on 17 July 2023. And the reasoning, my lord, starts at paragraph 43. At ink page 67, my lord, if my lord permits me, writ appeal 1009 of 2023, my lord.
Before the interim order was passed, you have admitted the student.
No, madam, we cannot. It's only after the interim order. Do we have the interim? We have the interim order. Interim order is at. I've not enclosed the interim order, madam.
No,
But it is referred to
3110. It's at page 131,
in which
3899. So writ appeal 1009 of 23. The interim order is at page 131.
thank you.
Yes, your lordship. The penalty was directed to be paid. But what needs to be seen is we had sought the
First order is at ink page 130.
in line with so I'll just make my submission. Under the NCISM Act of 2020, under section 28(1)(f), NCISM is entitled to initiate proceedings for any of these violations. Therefore, we had sought for liberty to be reserved in our favor.
For 1890. For 1890. Okay, so 4728. Over 1820. Yes. Next order. 2020.
Grateful.
Any date, ma'am? Please. Yes, ma'am. Yes, ma'am.
Yes, there are.
In fact, we have looked at the timing because 18, 19, 19, 20, 20, 21, the academic calendar is fixed. Therefore, they have to complete their procedure in a time schedule. Grateful.
7-3.
Because all the
Obliged.
students, my lord, all the students who are passed will be under the order of this honorable court, writ petition, so and so.
That continues.
All the students who will come out of the institution,
They'll have an additional
there
stamp.
as a writ petition number so and so,
They'll have an additional stamp. That's what.
additional stamp.
Yes.
Fourteen. Ratio Prakash. 14.
Appellant, my lord. That's some office objection, right, my lord. Translated copy, sir. Please, ma'am.
15.
Appellant.
15.
Suit for adjournment is dismissed. Lord was pleased to issue notice. I have paid process on 31/1 itself, please, my lord. I'm not getting any rents now. They are in occupation of the property. In fact, my lord, in October itself, they said they will vacate and hand over possession. I have produced a copy of emails also. If my lord permits me, I can take my email, please. Handsome and settle, please. Any shortest possible date. I understand, my lord, but I am deprived of my rents also.
18-6.
Not somewhere before vacations. A short,
Next.
6.
please.
16. Shri Chandrasekhar. 16. 17.
Paying my appellant in this case. Worship, on 5/2, I filed my NOC wakalat. Worship, but the cost list still reflects the name of the previous counsel. And regarding the amended cost title of the arbitral award, your lordship, I have obtained the arbitral award. I'll be producing it in the. Please, your lordship, I've just come on record on 5/2 and request for short accommodation. Please, your lordship, 5/2/2025, I filed my NOC wakalat, but cause list is still reflecting the previous counsel's name. JP Darshan. JP Darshan.
Nineteen six.
Much obliged.
Serial number 18, Sri Prakash Angadi. 18.
Appearing for appellant, my lord.
24-6.
Grateful.
19.
Praveen Kumar.
Lordship, I represent the appellants in this matter, Lordship. Due to some technical, the reasons, Lordship, I could not complete the office discrepancies which raised by the registered Lordship.
Lord, they kindly directed, they have not served the one appeal copy and yes, I am the contesting respondent.
Will do, Lordship, will do, Lordship.
State.
No only will share the soft copy with them, Lordship.
Hard copy. Acha.
It's consideration of IA, Lordship. Just I filed a recalling application, Lordship, to complete the office discrepancies, Lordship.
Here number
Right.
20, Prakash Shangri.
Respond.
20. 24/6. 20.
Please, my lord, in this matter, the advocate for the appellant was here, my lords. He has just gone. We taken a day after, my lord. It's a money recovery suit. Where is admitted liability? What, my lord? That amount have a permit withdraw, my lords. He has deposited, my lords. He has informed. I am permitted to withdraw them. But he was here, my lords. I don't want to make submission in his absence. That's the reason. What, my lord? He has admitted the liability, my lord. It was payment for the services rendered. Would we have debt to my lord? I'll inform.
Seventh April. 7th April. Sir, 7th April.
Got you.
22. Serial number 22. Shri Somshekhar Naidu. - 23 adjourn. 25. Serial number 25.
The respondent, my lord, we moved this. We have, as per the directions, we have also served the other side, my lord, the appellants. Sought for an early hearing because the second time this appeal has been filed pursuant to an order by this. Yes, my lord, because the award is about 7-8 years old. So this side is the department counsel appears. Only Krishnan. Generally he appears. 23 form. Very well. Grateful.
26. Prakash Shangri.
This is before the arbitration court, my lord, the application rejected on 34-3, my lord, section 34-3.
My lord, 50% amount has been deposited, my lord. And I'll take an instruction from my senior, my lord. Prakash Angri. Please.
27 adjourn. 28 adjourn. 29. 29. Hriday Mathur. Serial number 44. 14%. Shri Nagaraj.
P.S. Mali Patil.
Yes.
My lord, this is about the financing the respondent number 2 by the respondent number 1, ASFC, to Vishwarupa Visions Private Limited. The company was instituted by us. The cases, we approached the KSFC for assistance, financial assistance. They have agreed to give loan for the project with the a sanction letter void annexure C, page number 180. As per the terms and conditions agreed by both of us. Subsequently, my lord, I have already given everything in writing in the written submission. This appeal is a continuation of the trial court orders and judgment, decree and judgment, and we are seeking for partial modification of the trial court order and judgment for relief. To substantiate for relief, we have placed substantial documents before this court. Today, I have no idea, but as per the decreed date, it is around 1 point. My lord? 1,63,299 at the date of institution of the decreed date. We have approached, they have sanctioned the loan for 45 lakh rupees. Since they asked us, then they asked us to, commission, show us the premises, show us the equipment, since because the equipment supplier, we have given the proposals where we are going to buy the equipment and all. Then the case of said the equipment supplier is not a registered one, so you have to show us the equipment, place, install everything, and after inspection we will release the loan amount as per the contract signed by given by them. So we have paid all the advances and we have secured the equipments and installed the plant and machinery, and then we got project was graphics and video editing. And also it had the inbuilt capacity to make CD-ROMs and others, because CD-ROMs has a good market in the United States. So in that context, we have started. We have offered, we have 45 lakhs. We have installed, we have paid the advances. We have paid the advances and installed the equipments, and we offered for the inspection. Inspection is also conducted by the KSFC. After that, they have agreed and given the contract letter. We have showed we have offered our own collateral securities with in our same capacity what we had. So they have taken those things, but a shortage of 1.8 lakh rupees has to be provided. So we were willing to do that. After installing, we have paid the money was blocked. Our all investments were blocked. So now they went back on their words. They are asking for a single immovable property in Bangalore. Our own personal, it was, we have given in the sanction letter, it is already. Earlier, our own properties, house, it was in Chitradurga, Chalakere. Chitradurga district, Chalakere. They wanted, after the loan was sanctioned on the. No, we are willing to give. They did not take it. The sanction was made on the basis of the collateral securities which we have been offered. There was a shortage of 1.85 lakhs. So we have agreed to make some arrangements. they went back their own words. They wanted a single property in Bangalore. So we didn't have. So they have arranged by themselves a third party collateral. He is not a member or a shareholder of the company, a pure third party. And we have made to, because our money has been blocked, they asked us to pay some money and other things. We have given a agreement. We will get it released and other things at the time of this thing. So we have paid some money, made us to invest again. We have given they have modified the collateral security, and then the entire process is being done. The first release was made despite of having the entire unit was made and the hypothecation has been made first, all the equipments. Then they have released only 16.6 lakhs on again, yes, again it's 45 lakhs. They have only released. $45 lakhs, only 15 lakhs, 16 lakhs has been released in the first. After lapse, so the equipment supplier was upset. No, this commitment letter has been issued to the equipment supplier. My lord? We have paid around 20 lakhs or something like that. Again, additional 25 lakhs has to be given by these people. We have already paid advances for the premises. We already started 3-4 months rent. Then we have employed people. All those things were made, arrangements were made, but they have only given 16 lakhs release to the 45 lakhs. This thing, they have given only 16 lakhs. So he has taken half of the plant and machinery back. Only what, he has left only for the amount that has been released. Again, we are stuck with the initially we have got when, put into trouble. After 2 months, again they have, paid the second installment of 20 on rupees 20 lakhs again. So they have again it was completed. But we have purchased additional equipments with our own funds that they did not release. Total amount was released only 37 lakhs. Still 8 lakhs, 7 lakhs was still pending. But we have secured from our own funds. But they have without financing, they have hypothecated those items also. Then late, they have kept it this thing. We because it has become sick in the initial. We didn't because all our funds have been locked. We did not have any, working capital for us. So we in the meanwhile we have borrowed some money from and loans and other things. We have produced certain things that were having big market in United States and other things. Like I have already produced the CD-ROM and other thing. It was having 2 years, they did not do anything. We approached this thing for, working capital or release the balance amount. But at that time, they have already taken the all equipments as hypothecated. They did not release the balance amount. Finally, they have released the entire amount, 6 lakhs, and adjust our dues without releasing to us. Our investment is also blocked, which is violation of the Contract Act. First, they have not released the entire amount, principal amount to the project. It was in the year 1996. On the first day of release was 4/11/1996. 1996. Partially is given. Second installment after 3 months. After 2 years, they adjusted the balance 6 lakhs towards dues without without taking the consent of all the directors, which is a mandatory section under 62 of Indian Contract Act. They adjusted, and all our this thing was blocked. We did not have working capital to continue the project. The unit is, by the time the equipments were broke down. We didn't have money to repair it also. So forcefully, they have closed the company, prosperous company. Even we have approached the Confederation of Indian Universities, the educational materials or across the industries for at that time ISO 9001, it has been started. So lot of educational materials to industries were required. They have given a letter also that I have also produced before the court. We have all these documents that we have given to the KSFC. We have not kept the financial institution in dark. But they have promissory stoppage. They have broken the contract. Secondly, they have adjusted towards you. It's not a part of the contract. They made the company sick from the day one. They have taken part release. They have taken the equipment pass. We are not unable to continue this thing. So finally, they have adjusted this thing. That is also violative of that thing, violative of Indian contract. We have made to suffer for almost 3 decades for livelihood. We did not have it. Other people, they want, because the collateral security paper started asking us to get it released. We were continuously harassed by them. We were willing to change it over this thing. So in the due course, because the liabilities has become more, the project has been incomplete. We didn't have working capital. So we are seeking for a relief. Then finally, after a lapse of this thing, they have filed a recovery suit. They have tortured us for almost 3 decades. I have also given certain citations in support of my thinking. We need the partial modification. My lord. And we were also, they called for, after a lapse of 4 years, they called for a DRC committee. That whatever the lapses has been, they have the authority to rectify. They can reschedule the loan. They can, invest, they have the authority to give working capitals. Nothing has been done. DRC committee has suggested for one-time payment of 6 lakh rupees. We said we are agreed. We are in the opinion that we have made the correspondence to give this thing letter so that we will close the account. But they didn't do it. They went back on their own words. Then they started harassing us. They have filed, they published in the newspaper that we are absconding. Then they have filed a police station. They did not take the equipments also. Till DRC committee happens, no relief can be sought by us. No relief before the court of law. Even specifically, relief can't be, sought by under Article 226 also. Balance to pay, release the amount or such thing. No relief can be granted before the court till the DRC committee happens, because the high level committee formed by this thing, they will be deciding authority on this account. So they have suggested for one-time payment. We are agreed, but they did not do it. No, they did not do anything. You have to pay so much. You have to pay. Then they have, that's all. Nothing else. They did not declare that this thing, because there is an opportunity we have produced. If they give working capital, we would have continued with it, but they didn't do it. My lord, we have not paid. That's all. It is due. Issues. Yes, my lord. The entire thing is, it is allowed in part and dismissed. Like whether the petitioner corporation proves that it is entitled to recover 1.63 crores as 47. These 3 points are taken together, discussion on the same interconnected with each other in intention to avoid repetition of facts and discussion. The petitioner corporation has filed a petition under section 31 and 32 of SFC Act for recovery of 1.63 crore 63 to 28,990 as on 10/12/2003 from the first responsibility with the future interest of 22.5 per annum compounded at quarterly rest till the realization of the entire amount to pass in order to enforce the liabilities of the respondent number 2 to 9 guarantors to pay the sum of 1.63 1 crore 63 lakhs 28,900 due from the respondent number as on 10/12/2000 payable with a future interest of 21.5% per annum compounded quarterly till the payment of entire amount for confirmation of provided order of injunction with respect to petition scheduled property and such other reliefs and costs. Shrikant, manager of the petitioner corporation, has adduced evidence PW1 here. He has exhibited EXP 1 to 16. Exhibit number 1, document P1 Gazette, P2 loan sanction letter, 3 guarantee deed, 4 office copy of legal notice, 5 a copy of the statement of account, 6 reply to notice of respondent number 8, 7 reply notice to respondent number 5, and P and 8 postal acknowledgement, sealed undelivered post covers. I have also led the evidence. I have given the exhibit R1 certified copy of the complaint filed by the petitioner, R2 certified copy of the charge sheet filed by the sealed in the CC number 1847 of 2003, certified copy of the judgment dated 7/1 of 2000 in CC 18473 of 16. The BS Umesh respondent has added his evidence and he has marked exhibit 4 to 6. Intimation letter of 24/8 sent by respondent number 3 to the petitioner, copy of form 32 acknowledgement issued by the Register of Companies. PW1 has reiterated petition averments in his affidavit. Evidence like RW1 and 2 have reiterated the averments made in their objection of statement respectively in their affidavit evidence. It is the case that the petitioner, that the respondent number 1 is a private limited company incorporated under the provisions of the Company Act 1956. The respondent number 1 company has approached the petitioner corporation to avail loan for the film processing unit. The petitioner corporation, after considering the loan application of respondent number 1, has sanctioned the loan of 45 rupees void sanction order AGM ADM2 TA 244 HD 169 dated 5/9/1996. The petitioner corporation incorporated the terms and conditions of the loan in the sanction letter. The first respondent has executed the hypothecation dated on 25/10/1996, hypothecating the effects mentioned in the schedule therein. The first respondent has also executed the loan agreement dated 25/10/1996, agreeing and undertaking to repay the term loan of 45 lakhs in 25 quarterly installments. The first respondent had already agreed to pay the loan amount with interest of 21% per annum, with a rider to pay interest 22.5 per annum in case of default of the payment of installments. The respondent number 2 to 9 have executed the continuing deed of guarantee dated 25/10/96, agreeing to undertake to pay the loan installment first respondent in case of default committed by the respondent. In spite of various concessions, the first respondent has failed to pay the loan installments. Hence, the petitioner has issued statutory notice under 30 of SFC Act and recalled the loan. A copy of the notice was also issued to the guarantors to enable them to prevail from first respondent company to clear the dues. The respondent number 1 has failed to comply the notice issued under section 30 of the Act. Yes, my lord. Okay, to a principal amount, 45 lakhs is the loan. Best has been adjusted to us, which is against the contract. They may, all our money has been blocked. We are not able to continue the only once. The entire amount 6-7 lakhs. Once they have adjusted yours at once. That was on after 2 years. That was on 20. After 2 years from the date of loan. The quarterly instruments. Yes, but they are adjusted to due 6-7 lakhs on 24/3/96, 1998, after 2 years later. They have not taken any actions. They were only coming. $37 lakhs has been released to the equipment supplier, which has been supplied directly to the equipment side. They have not given. Whatever some interiors and other things, small amount has been released to the company directly. Additional 10 lakhs. That was not made because at least oh, they are, yes, but they could not take it because they have hypothecated the item also by the KSFC without releasing the money. Later, they have sold the equipment by seizure, and they have sold our equipments. No,
We have sold those equipment we have seized. How much for?
It's some small amount, around 1 lakh or 2 lakhs. They have taken the third party collaterally. They sold recovered around 20 lakhs and returned the document to him. Third party collateral security that they have arranged, they have collected 20 lakhs and they have given back the papers to them. Equipments were taken and sold. Under section 29, the company's liability is only to the limited to the extent what has been offered to the KSFC that they have taken. Now they have filed a petition to recover further against the guarantors. That is too different. And they have broken the contract. They made us sick, the unit made sick. No efforts were made to revive the unit. And finally, we were made to suffer and they filed a criminal complaint. They made a civil complaint. At that time, we did not have money. We have suffered a lot. I've been left out with no other reason that I have to pursue on myself. No other advocate will come. Legal authority refused to give us the legal assistance. So I became a party in person. From that day onwards, I'm pursuing the matter. They cannot go against the guarantors because they have broken the contract. And citation is also there from the Supreme Court judgments. And also there is other Supreme Court judgment is there. Novation has to be made. The adjustment has to be made. If that has to come on the modify the contract that they have not done, taking all the consent of all the directors and modified, nothing has been done. Rest it is a mechanical something, and they put us into trouble. 22nd. Sir. 22nd, I have to appear before the other court. 23rd, 24th. 21st, okay. 21st is. My lord, shall I have reorganized the written submission so that it will help to assist the court. Huh? And event of dates and other things. Event of dates accordingly have. We need relief. We have suffered for 3 decades. We need some relief, my lord, please. Yes. Number 30.
My lord, I'm for the respondents, my lord. I filed an application for early hearing. This is a suit for eviction. There's a decree of eviction against the appellant, my lord. And they've not been paying me the current rents, my lord. It is a commercial property they have occupied. They're not paying me
There is
the
a
rents.
deposit of rent before this honorable court, please, my lords. My lords, there is some other counsel appearing in this matter. Today I've been informed that the counsel has given NOC. I just entered appearance today by filing wakalat in the counter.
My lord,
I will verify exact status of the rent, please, my lords. If at all anything is arrear, I will have it paid. But what I am told is that as per the orders of this honorable court, the rents have been deposited
My lord, if I may
before this
explain-
honorable court itself.
Please, if I may explain, my lord. The, as per the orders of this honorable court, my lord, it was ordered that 75% of the decretal amount will be deposited. The decretal amount, my lord, included only rents up to the arrears of rents for past 4-5 years, up to the date of filing the suit, which is up to September 2023. From September 2023 till date, my lord, again, they have not paid me the rents. So they want a stay of the eviction order, but they don't want to pay me the rents. Please, my lord. And even the sums that they have deposited, they have not calculated correctly because the decree includes the cost, interest, everything, my lord. They have filed that. Please. Please. As per the decree, my lord, it is ordered and decreed that the suit filed by the plaintiffs is hereby decreed in part with cost. They have filed a memo, my lord. They have not included the cost. It is further ordered and decreed that the defendant is hereby directed to quit, vacate, and deliver the vacant possession of the suit scheduled property and shall put the plaintiff in vacant possession of the suit scheduled property within a month from the date of this order. That is from October 2024, I have a decree of eviction. It is further ordered and directed that the defendant is hereby directed to pay a sum of rupees 55,39,000 so and so within a month from the date of this order, being the arrears of rent, interest, together with future interest at 18% per annum from the date of the suit. My lord, what they have calculated is from the date of the decree. From 1510, they have calculated the interest, my lord. So even here, they have short deposited it. From September.
I will verify, please, my lord. I'll verify if there is any shortcoming. I will have it deposited.
My lord, even currently, my lord, the lease deed was executed in the year 1990. It was only for a period of 20 years. It expired in 2010. Admittedly, it was not renewed, my lord. So from 2010, both the parties have taken the risk of having it on a month-to-month basis. Then till 2018, they paid me the rents. We had good relations with them because they were with us from 1990. From 2018, when they refused to pay, they cited COVID and various other reasons. It was an hospitality industry. We agreed to not to precipitate the matter. But then in 2023, in spite of a repeated request when they did not pay the rents, my lord, we were constrained to file the suit. And the rent that is paid from that, my lord, is only 90,000. From that 1990 lease deed, they want to pay me the rents. Today, my lord, in that area, they will not get a 2 BHK apartment for 90,000. They have my 36 BHK commercial premises, which they're using for hotel business, my lord.
And they don't want to pay me even any rents. They want a stay of the eviction order. Arrears from 2018 till the date of filing the suit. The future damages, my lord, there's an inquiry for mean profits which is triggered, which we have to yet file, my lord, because currently we are told that 200 rupees per square feet is the rate today. Please, my lord, that I will, please, that's a separate inquiry.
How much is the monthly rent they have to pay?
It will be about 1 lakh, my lord.
In terms of the lease deed, you haven't seen.
Please, the same lease deed.
I will verify, please, my lord. I'm not aware of it. I will verify, please, my lord.
Equity rent you will pay.
Please, my lords. Whatever.
20 years have gone by.
My lords, what has happened, what I'm told is there are nine landlords to the property. Only 4 of them are before your lordships. So I need to find out how much is the rent payable to these 4 landlords, because the other 5 landlords also pay.
They separately,
No, it's a joint lease, my lords, of the property.
joint lease
Please, my lords.
with all of you, or with others also. Subject matter of the suit by you,
Please, my lords.
right? So how much was the lease amount in terms of the?
My lords,
lease deed?
as I told, I just got the brief in the morning. I'm not fully aware. I will please, my lords, if time is given, I will come prepared fully. And I'll please,
Please, I've been making applications even in the lower court, my lord. As per my application in the lower court, 90,000 rupees was my share of the plaintiffs before the court. 90,000 rupees, the share of the plaintiffs before the court. Because there are 9 landlords. Please, there were other co-owners.
Against him only or? others?
Against him only, my lord.
By all the
By all the co-owners together. The total rent, my lord, as per the lease deed of 1990, it was 35,000 rupees with 5% increase every 5 years. So calculating on the same terms, it would have come up to some 1,30,000 as on this date, my lord. And the share of the 5 of us who are before the court would amount to 90,000. I've made that application even in the lower court. They are aware of it.
Why the other co-owners have not come?
They are in US, my lord. I have not been able to contact them.
Keeping them in this.
No, my lord, I'm not representing them.
Extent of your share.
Please, madam. Our share is 60% of the total rents. The remaining 40% of the landlords, they were in the US and we were unable to contact.
I may be given little time, my lords. I will find out the exact position and I'll update this.
So loss for me, my lord. Every month that goes by, it goes without rent. Apologies.
Percent.
75%. Please.
Rent with effect from?
So from September 2023.
If any, short of- Okay.
Please, my lords.
Effective from September 2000. Yes.
47, my lord.
A date may be given.
Serial number 47, my lord.
Not
I have moved, ma'am.
respondent, please.
Please. My lord, if they do not deposit, if it can be had next week, my lord, if they don't deposit, at least there can be a,
No, my lords, whatever,
interim order can be
if there is a
vacated.
shortcoming, we will make sure that it is done, please.
Very good.
Great. Great.
Please, my lords.
31. Number 31.
Lord, I appear for the appellant. My lord, challenge to an arbitration award. My lord.
Yes.
When a challenge to an arbitration award under section 34 was repelled, this appeal, my lord, is filed challenging that order. My lord, the grievance, if your lordship will now look at the award. First, my lord, let me point out to your lordships, what is it that has been granted by the learned arbitrator? My lord, the award, if your lordships are kind enough, my lord, to see page 258. 250, 258, my lord. The claimant is directed to pay to the respondent a sum of rupees 15 crores towards refund of security deposit amount. And in addition, the claimant shall pay 1.06 crores to the respondent, which is the interest paid by respondent to IDBI Bank. The claimant is further directed to pay to the respondent a sum of rupees 1 crore 67 lakhs 47,000 towards pro rata charges and 2 crores 78 lakhs 53,610 less the amount deposited in center in a sum of 1 crore 65 lakhs 65,000. That is 1 crore 12 lakhs 80 towards VAT, GST and other taxes. Claimant is also directed to pay to the respondent to the electricity charges of the claimant flats from February to July 2022 in a sum of 1,14,057 and shall continue to pay to the respondent the said charges of the claimant share up to the date of the claimant selling all the remaining flats fallen to his share. Claimant is also directed to pay to the respondent towards maintenance charges of claimant's flat from February to July 2022 in a sum of 26,79,520 and shall continue to pay to the respondent the said charges of the claimant share up to the date of the claimant selling all the remaining flats fallen to his share. Claimant is directed to pay to the respondent towards clubhouse charges in a sum of 85 lakhs. The total amount to be payable is tabulated there. I have agreements with respect to each one of this, and I shall point out to your lordships how, in respect of most of what has been mentioned here, excepting the 15 lakhs, there are no documents. But I want to point out to your lordships one thing. If your lordship will kindly turn to paragraph number 93. There is I have prepared a written submission synopsis. Can we place it for your lordship's consideration? I will point out one glaring error in the award. And if I am right in that, then of course the entire award will have to go because there can't be a partial setting aside of an award. Now, my lord, please look at paragraph number 93. Your lordship will kindly see, my lord, in so far as electricity charges and maintenance charges is concerned, the learned arbitrator has granted 1,14,057 and maintenance charge of 26,79,520. Your lordship sees that. Now, kindly see, my lord, what the learned arbitrator says at paragraph number 93. Insofar as electricity charges and maintenance charges are concerned, parties will have to work out the exact amount paid by the respondent toward these heads, taking into account the BESCOM bills produced at R52. And as far as clubhouse charges is concerned, since the clubhouse charges are to be worked out as per the revised share in the agreement to be executed, parties are to abide by the said revised sharing agreement and also abide by the sharing agreement exhibit P5. As the sharing agreement at clause 10 makes it clear that all the terms of the relevant agreement exhibit P1 remain intact, and the sharing agreement shall not be deemed to be a waiver of any of the parties' rights. Both the parties will have to abide by the terms agreed to between them. And as some more flats are remaining to be sold, inasmuch as there is an order of injunction restraining the claimant not to sell 9 flats and the respondent not to sell 8 flats, during the pendency of this arbitration proceedings, the parties therefore will get the right to sell the remaining flats fallen to their respective share only after conclusion of this arbitral proceedings. In other words, with the passing the award, the proceedings would come to an end. An interim order not to sell the remaining flats will not be in force. Now, my lord, as to how this maintenance charge of 26,79,520 has been arrived at is just not there. He says it has worked out. The only reference
Yes.
now, my lord, I point out your lordships, my lord, about his clubhouse charges. Your lordships may kindly turn, my lord, even with respect to clubhouse charges. Para 93, what I read to your lordships. My lord, a total amount of 85 lakhs is granted. There are no reasoning in the award as to why electricity charge of 1,14,000 is granted, maintenance charge of 26 lakhs is granted, clubhouse charges of 85 lakhs is granted.
Yes.
And now, my lord, kindly look at this amount toward GST and taxes which have been granted, my lord, to the extent of 1,12,88,610. If your lordships are kind enough to turn to paragraph .
So we take it, Mr. Albert, you are only contesting this 85 lakhs, 26 lakh, 1 lakh and GST.
No, my lord, I am contesting the others also, but I am now pointing out to your lordships how, on the face of it, this award is erroneous. If it is erroneous on the face of it, even in respect to part of it, the entire award has to go. Because today, my lord, until the Supreme Court, my lord, settles that issue, today the legal position is that there cannot be a partial setting aside of an award. Whether it is right or wrong is what the Honorable Supreme Court will decide, my lord, in matters which are pending before it. I am given to understand some arguments have been advanced.
That is, my lord, modification. As far as if a portion is bad, Supreme Court has already said that, my lord, that portion can be taken out and the rest, my lord, can be confirmed. If judgments are needed, my lord, I'm sure my learned friend knows about it.
That unfortunately, my lord, is not that clear today. That's the exact argument that has been advanced. That's that argument that has been advanced. Now, if it is a case of modifying an award which is already passed, which is one award, it may have many other things. It still amounts to modification. My lord, security deposit, my lord, my respectful submission is that there is a delay and the learned arbitrator says, because of RERA, I will not be able to go into it. On the question of delay, the learned arbitrator says, because your claim is for delay and it is because of the provisions of the RERA, I don't have jurisdiction. It is only the RERA authority which has got jurisdiction. My lord. No, arbitrator has gone into it and given a finding saying, I don't have jurisdiction. Yes, my lord. Yes, yes. My lord, may I just take your lordship through my written submissions, my lord? We have put everything down. But may yeah, I put one by one, my lord, everything. If your lordships will permit me to just take your lordship through it. May I have your lordship's permission to just quickly run through this, my lord? The appellant is the owner of the property in question, which was a site with old dilapidated house. The appellant entered into a development agreement with the respondent on 22/10/2012, Exhibit P1, volume of so-and-so, with the respondent. The principal terms being Clause 1A, development right and sharing 50%, 50%. 1B, developer to construct at its cost and deliver 50% of the super built-up area to the owner absolutely. Developer to obtain sanction of plan from BBMP within 6 months from the date of the development agreement, that is on or before 22/4/2013. Developer to commence construction immediately after obtaining building plan. Developer to complete construction within 30 months from date of commencement. Note number 1, 11/1/2016, plan was obtained roughly delay of 3 years. Even for the purpose of obtaining a sanction plan, that took 3 years. Whereas under the agreement, my lord, they were supposed to obtain the sanction within a period of 6 months. The developer therefore had to commence construction immediately after 11/1/2016. Developer applied for commencement certificate only on 5/11/2016, that is after 10 months of plan sanction. 19/1/2017, developer obtained commencement certificate. In case of delay, developer to pay ₹15 per square foot of saleable area falling to the share of the owner. It is the case of the claimant that the respondent delayed enormously in completion of the construction and has violated all the terms of the development agreement and hence claimed compensation under Section 18 of the RERA Act 2016 and also claimed amounts for not achieving maximum FAR. The arbitrator under the award has directed the appellant to pay following amounts. The same is mentioned here, what I point out here. Well, RERA, we have not gone there. No, my lord. We said under the provisions of the RERA, there is a provision for payment of delay compensation. Please award it. Our basis of our claim before the arbitrator was RERA. The learned arbitrator says that I can't do anything about RERA. If your basis is RERA, go and do whatever you want before them. Of course, my lord, I must state. No, my lord, I was the claimant. Yes, my lord. They had a claimant. They had a counterclaim. Yes, I was the claimant. Yes, my lord. Yes, my lord. I was a claimant. I was a claimant. Now, my lord, kindly see, my lord. My claim was based on respect. My claim was based on. Now, my lord, kindly see in addition to 15 crores, the learned arbitrator, my lord, says I should also pay 1 crore 6 lakhs, which is the interest which has been charged by IDBI Bank. Now, kindly see, my lord, why we are objecting to that. It is a loan that I had taken. Now, my lord, 15 crores, he says I have paid it to the bank. Now, kindly see why we are saying it is bad. The arbitrator and the award has directed the appellant to pay a sum of rupees 1 crore 6 lakhs to respondent, stating respondent has paid the said amount to IDBI Bank as there was delay in loan repayment by the appellant. At para 94 of the award paid 255, the arbitrator has held that the appellant has discharged the loan amount to IDBI Bank. In cross of RW1,
Oh, you are ready. Sorry.
at para 94 of the award paid 255, the arbitrator has held that the appellant has discharged the loan amount to IDBI Bank. In cross of RW1 at page 116, the respondent has admitted that whenever demand asks for payment were given, the appellant immediately used to pay it to the IDBI Bank. It is stated that the appellant had entered into a JDA to clear the loans. The respondent failed to pay rupees 25 crores in time. Respondent took time to pay 25 crores to the appellant. Hence, the arbitrator finding fault with the appellant and holding that the appellant is liable to pay interest of 1 crore 6 lakhs is in conflict with the most basic notions of morality or justice. Yes. My lord, we have not paid what this amount, my lord, had the amount that is to be paid to the bank was to be paid from out of the money which the respondent had to give us. Respondent did not give it on time. Therefore, there was delay. Therefore, my lord, I am not liable. That is the argument. I showed your lordship that, my lord. I showed your lordship when I come to those paragraphs. Further, at para 6.2 of the objections, page 4 and para number 8 of the counterclaim at page 38, respondent has made a claim of 1 crore 6 lakhs because respondent alleges it was forced to clear the IDBI Bank loan amount. At para 94 of the award, page number 255, arbitrator has held that the respondent was not compelled to clear the loan amount. Hence, the arbitrator still holding the appellant liable to pay 1 crore 6 lakhs is in conflict with the most basic notions of morality or justice. My lord, even if under the Contract Act, even if somebody has discharged my liability, then, my lord, the question is, was there an obligation on the part of that somebody to discharge it? If you have gone and voluntarily paid it, you have paid it at your risk. There must be, my lord, an obligation on the part of a third party to clear my liability, and only then I am liable to the third party. And when the arbitrator says that the respondent was not compelled to clear the loan amount, why did they go and clear it? How can, just because they have paid the money, in answer to your lordship's question, have they paid the money? They have paid the money. Why did they make the payment? Was there any obligation on their part? Did they notify us before saying, I'm sorry. My lord, the bank would proceed against me.
Against the land, my lord, mortgage.
Did they notify us? They should have notified us and said, look, so much money is payable. The bank is demanding it. Was there an obligation on their part to discharge it? And when the arbitrator said there was no compulsion on you to repay, then, my lord, this liability cannot be put on my head. I would have possibly negotiated with the bank and said, look, 1 crore 6 lakhs is too much. My lord, it's all very easy, my lord, because my money is with them. They just go and pay it. After all, further at para 6.2 of the objections, page number 4 and para number 8 of the counterclaim at page 38. Respondent has made a claim of 1 crore 6 lakhs because the respondent alleges it was forced to clear the IDBI loan amount. At para, I read this, para 6. The amount of 15 crores is interest-free security deposit amount. The respondent making claim of additional amount and the arbitrator directing the appellant to pay interest at 12% per annum from the date of claim petition. It is beyond the terms of the development agreement, which is invalid and incorrect. But if it is interest-free deposit, there can't be interest on that. So that is the answer, my lord. Was 15 crores paid? Yes. Did they make 1 crore 6 lakhs to the bank? Yes. Am I liable to pay interest? According to me, no. Am I liable to pay this 1 crore 6 lakhs? No. Then, my lord, regarding GST claim. At para 24 of the counterclaim, my lord, your lordship saw, my lord, that the GST claim is quite a large amount, 1 crore and 12 lakhs 88,610. This is a claim in the nature of reimbursement. Obviously, my lord, they can't ask for GST if they have not paid it to the department. Therefore, this is in the nature of a reimbursement. Now, my lord, kindly see what the position is with regard to this claim. At para number 24 of the counterclaim at page 45, the respondent has stated that GST is not determined. That is to be determined by cost accountant or the GST department. The respondent alleges that so as to avoid any complications, it has paid a sum of rupees 2 crore 78 lakhs 53,610. The appellant in its written statement to counterclaim at para 11, page 131 and para 22, page 134 has disputed to the above claim. In the evidence of RW1 at para 57, page 99, respondent has stated the GST to be determined by cost accountant or the GST department. There is no evidence let in by respondent RW1 stating the GST amount is determined and it is entitled to claim the said amount. At para 112, page 167, the appellant in his petition under section 34 of the Arbitration and Conciliation Act has contended the appellant is not liable to pay any GST. Para 70 of the appeal memo, the appellant has challenged the findings of the trial court on GST. The findings of the arbitrator, when no evidence is let in regarding GST amount, is being determined and still directing the appellant to pay GST amount of 2 crore 78 lakhs 53,610 is in conflict with most basic notions of morality and justice. My lord, your lordship may kindly see, my lord, why is this 2 crore 78 lakhs 53,610 comes. If your lordship will kindly go to the award at page 258 at paragraph number B2. Yes. Yeah, that's exactly what I want to find. My lord, your lordship will kindly see at page 258. Award, counterclaim of the respondent is allowed in part as under Roman 2, man. So therefore, my lord, they have taken this money of 1 crore 65 lakhs, which was in deposit before the mediation, before the arbitration center. Therefore, if I am right in this submission, that money must come back.
Yes.
Okay, 2 crore 78 lakhs 53,610 less amount deposited by the center in a sum of rupees 1 crore 65 lakhs 65,000. That is 1 crore 12 lakhs 88,610 towards VAT, GST and taxes. And to this, there is no proof given how much have you paid, what have you paid. No record. It is yet to be determined even according to them by either the GST department or by the accountant. Then, my lord, your lordship, it is stated that the appellant disputed the aforesaid claim of GST. The arbitrator, by order dated 17/10/2022 in AC number so and so, has held that the parties should cooperate with each other and ensure the arrangements agreed upon to be obeyed in letter and spirit. And, my lord, the way the section 34 court has dealt with, my lord, is simply to say, this is the claim. These are not aspects which can be gone into in 34. That's a very Now, my lord, next, my lord, regarding electricity charges. At para 32, page 96 of the counterclaim, the respondent has made a claim for electricity charges of 1,14,057. At para 17 and 18 at page 133 of the written statement to counterclaim, the appellant disputes the said claim. No evidence is let in by the respondent. No reasons are given by the arbitrator in the award. The arbitrator holding that the appellant is liable to pay electricity charges is incorrect and illegal. Then, my lord, regarding maintenance and clubhouse charges. The respondent has made a claim of maintenance charges for a sum of 26,79,520 and clubhouse charges of 85 lakhs without any basis. The arbitrator allowed the claim of clubhouse charges at para 99, page 257, as per clause 6 of exhibit P1 at page 92, 292, volume 1. In the aforesaid clause, nowhere it is mentioned that the respondent can claim clubhouse charges. The appellant has disputed the claim of clubhouse charges in para 21 and 22 of the written statement to counterclaim at page 134. The appellant in his petition under 34 has taken a contention that nowhere in the development agreement the appellant has agreed to pay the said amount. Even at para number 72 of the appeal memo before your lordships, my lord, the finding of the trial court is being challenged. Regarding maintenance charges, no evidence is let in by the respondent to make the said claim. Admittedly, only 10 flats are handed over to the appellant in October 2022. The claim of respondent maintenance charges for the period February to August 22 is illegal. The appellant has contended at para 21 of written statement to counterclaim at page 134 that the flats are not handed over. The arbitrator holding that the appellant should pay the said amount is in conflict with most basic notions of morality or justice. It is stated that the arbitrator holding that the appellant to pay various amounts at various heads is illegal and contrary to law. It is settled law that the award cannot be modified. It has to be set aside in entirety. In this regard, the following judgment reported in 2021 and 2024, your lordships are aware, my lord. This is the issue now before the larger bench. Then, my lord, on this 15 crores, my lord, your lordship may kindly say, of course, my lord, an arbitrator, my lord, I must tell your lordship, holds that there is no delay, which finding, according to me, my lord, is perverse. Having held that, the learned arbitrator says your claim for compensation is under RERA, section 18, I have no jurisdiction. As an arbitrator, I can't. My lord, that I would submit, my lord, is wrong. In view, my lord, of the provisions contained in the RERA Act, the RERA Act does not bar an arbitration and reliance being placed on the provisions of the RERA Act as a basis of my claim. It doesn't mean that it is to be done only by the authority under the RERA. So therefore, my lord, that I have dealt. My lord, yes, I had. Yes, I had. I had. In fact, my claim statement says so. One of the reasons why, my lord, the learned arbitrator holds that I cannot rely upon RERA section 18 is to say that that provision applies only when you're an allottee. The question, my lord, is, am I an allottee? The learned arbitrator says you are not an allottee. Therefore, you cannot take the benefit of that provision. Now, please see, my lord, my answer to that. If your lordships are kind enough to turn, my lord, to para 16 of my written submissions. I say, my lord, that I am an allottee. Even in terms of the definition contained in the RERA. My lord. Not necessary is my submission.
And I have invoked. My claim is this.
Yes.
And I am only seeking the benefit of my, through your claim. This is the damages. The principle which will govern is something which is principle appeal.
Exactly what I've said. Exactly what I've said. I have said on the principle contained in the RERA, please give me these damages for delay.
prompted that it should be basically a principle withdraw.
That my submission before the learned arbitrator was the basis of my claim is rare. Huh? You give me the relief.
What is the effect of the counterclaim which has been granted?
My lord, then my lord, my claim itself is to the extent of 47 crores. The whole thing will go. My lord, I'm sorry. 47 crores. Yes, ma'am.
But tell us one thing,
Right.
so that your claim and their counterclaim were independent of each other.
My lord, independent but arising under the same development agreement. Yes. They said, my lord, my 15 crores must be paid back, and these are the various heads under which I must get the extra payment from the claimant.
They would have still got their counterclaims.
To a certain extent, namely 15 crores, yes, not the others.
Independently the challenge.
Yes, independent, yes, correct.
Those others have no bearing insofar as your claim is concerned.
No.
That was to be allowed.
Correct. That is true. If I don't succeed on my first point that the other claims have no basis, there is no evidence, there is no reasons. Yes. That's why, my lord, I challenge the award from B to F. Of course, my lord, 15 crores, they have paid me. It is a refundable deposit. I'm, of course, challenging, my lord, the liability to pay interest. Because it is an interest-free refundable deposit. Now, my lord, please be kind enough to turn to para 16. My lord, why do I say?
There is no interest awarded on the amount. Post arbitration award, yes, interest not under section 37. Learned friend probably is not properly.
Illa, sir. Pay 237 nodi. Nodi. Down nodi. 12% per annum from date of claim petition till realization. So it is not only, it is not kindly turned. Hold on. Please see page 237.
237.
ಯಾವ್ದು ಪೇಜ್ ನಂಬರ್ 259 ಅಷ್ಟೊಂದು ಪೇಜ್ ನಂಬರ್ಸ್ ಇದೆ
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ. So many page numbers.
59. This data 106 is independent of this interest which has been.
Yes, that is independent. Yes, my lord. Yes. Your lordships are right. That was the interest which they say they paid to IDBI Bank. Now this 12% is on the total amount of 18 crores. Yes, my lord. Pendency of the proceedings and future.
Not clear.
That also cannot be granted on 15 crores is my submission. Because it is a interest, even future may be different. But at least during pendent alike, they cannot till their entitlement was determined for refund. And now, my lord, please be kind enough to turn to para 16. My lord, why do you say I am an allottee? Is that approach of the learned arbitrator, my lord, right, is a respectful question that I place for your lordship's kind consideration. Then, my lord, that my claim on could not have been rejected on the ground. Well, my lord, this award must go. This award will have to go in toto. My lord, I know, my lord. I am also faced with the difficulty if the entire award goes. Then what will you do again? Unless your lordship says that this award on this will go, and your lordships will say under section 34.
Yes.
My lord, the only provision now available to the court as the law stands today is 34(4). There is no other provision by which we can go back to the arbitrator.
There, but that's only on the limit.
Very limited ground. Exactly. I know, my lord. I'm aware of it. But your lordship asked me, what is the remedy? Not a remedy in this case. Remedy in law is only 34(4), which is also very limited. I agree, my lord.
So if pending is some issue, then you are relegated to the arbitrator to work.
Yes, correct. Yes, my lord. Correct. I'm not saying that that course is available here. I'm saying, answer to your lordship's question, what is the remedy? Today, this is a only window that is available. Whether that window is available for this case is a different question. Please be kind enough to see para 16, my lord, of my written submissions.
But then the people rejects the challenge in totality.
My lord, my reading of 34-4, my lord, I would read it this way. If I have challenged the award on multiple grounds, and one of the grounds appeals, let me assume, to the 34 court. The 34 court may say, well, on this, I don't want to set aside the entire award. I will call for a finding from the learned arbitrator. That's so it need not necessarily be on the entire amount. It can be on one particular aspect of the award also, is what I fasten, my lord, from.
So far as
Yes.
order rejects the challenge to the section.
Correct, my lord.
In totality.
In totality.
Now, where is the segregation of the?
For example, I will answer your lordship. Suppose, my lord, let us take this award in question. The award in question, according to me, does not give any reasons in respect of items B, C, D, E, F. I will assume that. The one course available to the section 34 court to say, I will satisfy the entire award. There's nothing I can do about it. The other course available to the section 34 court would be, yes, I see that on B, C, D, E, and F, there are no reasons given. How is the award, how if it is to be determined? If the GST liability is yet to be determined, how can this be given? I will send it back to the learned arbitrator to have a relook at this and give me a finding. Maybe that's a course available. I mean, on a pure question of law. Considering, my lord, the conundrum in the law today with regard to partial setting aside, modification and all that, this possibly, my lord, is one way.
Ex facie, particular claim, particular challenge is maybe need to be upheld.
Yes.
Need to be rejected.
Yes. Yes.
But still that cannot be done in view of the position of law. Either you will uphold or you will.
Yes, yes, bro. Yes, bro. That's my submission. Now, how to get over this enigma in the law, the conundrum in the law? Possibly, my lord, it is if the challenge is on the basis of saying no reasons given in the award, no basis for the award, your findings in para number so and so is contrary to your finding in para number so and so, then, my lord, 34-4 may be a remedy. Can I finish one other point, my lord, and then, my lord? Can your lordship kindly see para 16, my lord? Your lordship asked me, how do I claim? I just have some basis. I will place it for your lordship's consideration, my lord. The claimant is an allottee under section 2D of the RERA Act. That's my contention. Section 2D defines the term allottee as a person to whom an apartment has been allotted. My lord, doesn't take us too far, my lord. Unfortunately, the word allot has not been defined. So we are still in the same position. What is the meaning of the word allot? Allottee is a person to whom a flat is allotted. Now, when does allotment take place? My lord, law is silent. Therefore, my lord, we are relying upon some. The word allot has not been defined. Therefore, there is need to have recourse to the dictionary meaning of the word allot. Now, my lord, I have the dictionary meaning, my lord, in Black's law lexicon and Ramnath Iyer's law lexicon.
Pay for damages under the RERA, on these proceedings, or effectively you are saying it is the RERA jurisdiction.
No, my lord, I am saying the principles under RERA, I showed your lordship the claim statement. I am saying having regard to the provisions contained in section 18 of the RERA, I am entitled to damages at this rate. In the light of the, my lord, I have answered that, my lord. In my note, I have put that also. In my note, my lord, I am coming to you. I have put that also. Let me just place this allot definition and then go to the next point.
See, the bar of jurisdiction contains every issue be read along with section. When so read, there is no bar.
There is no bar.
After so read.
My lord, I'm not saying there's a bar to RERA, but the question is there a bar to approach the arbitral tribunal? I understand, my lord, I can go to RERA, but if I have chosen the remedy of going to the arbitral tribunal, is it right to say, sorry, don't come to me, the only authority is RERA? That's what the learned arbitral tribunal is saying. I don't have jurisdiction to go into that question, your remedy is elsewhere.
You can have either RERA or.
Exactly, that's my option. That is what, my lord, I have put in my note also for your lordship's consideration. Yes, my lord, the National Law School matter, if whatever. Yeah, I'm ready. I'm ready at that also.
My lord, may I make one submission, my lord?
Yes.
Serial number 47.
Continues, I have three
Yes.
matters, I say.
I am held up in a parklet in the afternoon.
Let
Could
him
it be
complete.
had tomorrow, my lord?
We'll have it tomorrow, no issue.
I have paid 70B wages and all that.
You have paid it.
Yes, my lord. Yes, my lord.
Very well. We'll have it
Your lordship may
tomorrow.
have it tomorrow, my lord. I'll argue the matter in 15 minutes.
Very well. Just.
Much obliged. Deeply obliged.
Let Raghavan complete today. I have my lord some 2:30, my lord, some special bench and all that is there. So I may require, my lord, another date. I'll.
Just say that.
Anytime, subject to my thoughts.
No, yeah, we have another matter with Mr. Raghavan.
Your lordship.
Just say at the request of Mr. Kasturi, re-notify tomorrow. Yes, ma'am.
Serial number 22, your lordship. Our senior is held up in Supreme Court. May I request a date after 19th, your lordship? It's Passover case. Your lordship.
Just say that at the request of counsel. Who is the other side?
I have informed them, your
At
lordship.
the request of counsel for the appellant, re-notify.
My lord, serial number
We'll come back.
Thank you.
My lords, kindly, due to ill health, he got admitted in the hospital now because of this. Senior has been got admitted here on the serial number 38, can have it on 28th.
Serial number.
38 here. List one.
My lord's leave. Lord. Kindly, lords. Lord, serial number 22, lords. I'm extremely sorry. Morning I was held up in Court Hall 1. I came back. I know that I inquired it was passed over, my lords. There's extreme urgency for me that release of amount by the highway authorities, my lords. Somebody has mentioned from other side and they have taken a date by June, my lords. I'm running out of my funds. I'm completely. My lord. Lords, the other side counsel is one Mr. Likith. He has messaged me today. He has some matter in Supreme Court. He has requested me he has requested me saying that he will send his colleague and take an adjournment for tomorrow. I said, fine. But then suddenly it is jumped to June, my lords. Tomorrow, my lord, say, I'm extremely, I'm sorry. I shall call his colleague who is actually appearing in this matter every time. Lords, he's Mr. Likith. He requested me, since he is held up in Supreme Court, he said, please, he will send his colleague and request for tomorrow. I said, okay, fine. I don't know who appeared, my lords. He's one of his colleague who was mentioned at 1:30, it seems, my lords. I will take his number and I will also inform him, lords.
Yes.
Tomorrow, if it can be listed. I'll do it.
List, Srimati Revati,
Petition. The case, my lord,
Petitioner is the wife, my lord.
You had no issues.
No issues. Casual, I won't say he doesn't drink. Casually he drinks, but he is not an addicted person. They have put him in a center which doesn't treat. They don't allow him to go outside. They are not allowing him to access his wife. They are recording a video and sending to the wife. And when she went and approached and given a complaint that release my husband, they are telling pay 40,000, then we'll release him. And there is no doctors available there. And without the consent of the wife, the family members, the brothers, they have put him so that he should not ask any share in the property. His pharmaceutical shop is also closed by them. He's the only person who's a bachelor in pharmacy. Other brothers cannot run. They are running that shop also in his absence. If anything goes happen, it's going to come on him. And he's put in the addiction center, which is not a recognized institution. So she has approached the medical health department. She has approached the police also, my lord. But to her thing, no help has come yet. So except moving this honorable court. Respondent number 4 is, my lord, the center. Amma Foundation Center. They claim themselves to be an addiction center, de-addiction center. We have served on the SVP office, my lord. We have told him also we are moving at 2:30. We have informed him.
P2, Murugesharaki. Serial number 32. (23)6.
Yes, I tried to call him, maybe, I don't know, he is appearing before the court in Supreme Court, but he has requested me, my lords, to send a colleague only for day after tomorrow. I said, fine, tomorrow or day. I am actually ready, my lords. He has sent some proxy counsel, my lords. In fact, his anyways, I have. Yes, Lords. But I have informed the regular appearing counsel who's handling the case that, Lords, if it is tomorrow or day after tomorrow, I said I will not object. He's not picking up the call, Lords. May I will inform him, Lords, day after tomorrow, if it can be at least, my Lords. I'll call.
33. Ramesh.
May I please, Your Lordship? My lords, I'm on a very short compass here. The impugned order in this case, it starts at page 36, my lords. 39 is the operative portion. On 2 grounds it is dismissed. One is that I have given my consent to the order. And another one is that there is a delay, and then the advocate has not been appearing is 3 grounds.
one of the submissions that we would fairly make before this honorable court is that it is not as though the counsel for the petitioners has continuously remained absent. That part of it is one thing, Mellors. Your lordship may kindly see, Mellors, there were 2 dates. This was the second date, and on the second date, immediately in para 26, it has been explained in the appeal memo that it was a Saturday, Mellors. The counsel appeared in before that there was 1 date, and on that day, Mellors, though we do not stand by that, that's on the merits, Mellors. On the merits part of it, one is on the ground of latches and another is on the ground. On those 2 aspects, Mellors, the court should have given its finding is my humble submission. I will take your lordships through different aspects. If I can convince your lordship, then probably the fact that the learned single judge has not addressed on the question of delay or as on the question of this consent, whether there was consent or not, this aspect, then probably this court may have to take a different view. Now, Mellors, your lordship may kindly say, please, Mellors, that's what we have said here, Mellors, in 20. Immediately the lawyer went there and said, kindly consider it. The court said, I have also passed on merits. That's where, Mellors, we are before the lordship. Mellors, that would be one thing, Mellors. Our humble submission would be all that I am requesting this honorable court is, now that the court has given its finding on 2 counts. One is on the question of this delay and latches, and another is on the ground that I have given consent, but which I have not given. I can demonstrate before your lordship directly. That's one thing. So I would request, Mellors, all that I am expecting from this honorable court is, if on these 2 aspects, if your lordships are convinced, then probably if the matter is remitted back to the learned single judge, I will address on all aspects. 5 grounds we had taken, Mellors. Specifically 5 grounds we had taken before the learned single judge. That's where, Mellors, your lordship may kindly see, Mellors. This is a case, Mellors, where 21 guntas of survey number 52 of Kotihalli village of Yelhanka village, Mellors. Appellant and respondent 7 to 10 are the owners of the property. This was granted to them, Mellors, and re-granted to them, Mellors. Now, there is a preliminary notification of 13/1/83 and final notification of the year 85. Definitely there is a delay in our approach. But one of the grounds that we had taken was sanction was under normal rules, whereas if it is a cooperative society for which it had to be taken, then the scheme has to be approved by the government. Special scheme has to be approved by the government, which was not done, is one of the contentions that we had taken. And second one was that, my lords, an award has also been passed in this case, is what they say. We were never notified. I have produced all those documents along with the writ petition. We were never notified. One, Mr. Ananthamurthy, who is one of the office bearers, has taken GPA from all, is what they say. But our clear-cut contention is that we have never given power of attorney at all to Ananthamurthy. So assuming for a while I was heard, my lords, I would have requested the court to get the original records and see, look, there have been several persons who have given. Your lordships are aware that in many cases, the middleman handling has always been, condemned by the courts. And here in this case, what had happened was Ananthamurthy claims to have taken a GPA from all, including us, which is not true because our GPA was not there. We were so confident. We wanted the court to consider that aspect is one thing, my lords. And kindly see, my lords, the order sheet of LAC is dated 11/10/85, which is at page 119. Notice was also not issued, my lords. If your lordships were to see the LAC order sheet, which is at page 119. One 125. $125. In the case of 13-8-19, in the presence of Mr. Siva Ananthamurthy, he has given an agreement and indemnity bond and has already given GP. Case is reserved for award. Kindly see, my lords, this case, if your lordship so to see 119 page, ink page number 119, 118 is the first date, my lords. 22/8/85 was the first date. And next date is 11. 10/19/85. 119. Page 119, your lordship will get it. My lords. Eight. In our along with our writ appeal, we have different matters. One, attention to the order sheet of LAC case. Annexure G, Mellors. Please. Please, Mellors. Then we stand corrected, Mellors. Get the numbers corrected. I'm sorry, Mellors. Now, the next page is probably 129 if you have to add 10 here. Then case called parties absent. Please, Mellors. On that day, parties absent is what it mentions. We were not served with notice is our case, Mellors. 11/10/85 is the next date. Kindly see, Mellors, after 11/10/85, next date is 13/8/1986. Nothing happened. 13/8/86, they say this Ananthamurthy, who is supposed to be a GPA holder, has come and said, no issue, you pass an award and indemnity bond is given, is what they say, Mellors. Now, this is one aspect, Mellors. Now, Mellors, possession, the photos are at 143 to 147. Please, Mellors, everything has been pleaded. 143 to 147, some photos are produced, which your lordship may kindly see, Mellors. There have been samadhis, there have been everything, there have been houses. If your lordship so to see, 143 means probably it is 153, Mellors. Annexure L. Annexure L series. Complete series, Mellors. If your lordship were to come to 157, samadhis will also be seen. 158 also, Mellors. The date of filing is 25/7/2014. Photographs also show the name and date on which I have taken this. Now, here we have given the dates are given in the photograph.
We have a color.
40. Now, Mellors, our case is that, Mellors, please help. They started dispossessing us. It was at that point of time I came to know. All that I'm requesting is if I am given an opportunity to go before the learned single judge, I will play. And then
In the delayed actions, that can be, on the aspect of challenge to the acquisition.
my respectful submission would be this, Mellors. As far as consent award is concerned, if we see the record, it is not as though the court has not, it is not an error apparent on record. Probably it wouldn't fall is my humble submission here. It is a consent award. But not by the petitioners. That should have been gone into only, that will be a question of an incorrect inference drawn by the court. Pardon.
So effectively, there is a consent by whom is it? There is a consent.
There is that has to be deciphered and original records have to be called for and looked into. All those things will be a learned single judge.
Yes.
Sorry, learned single judge coming to a conclusion on its own. By looking at some records and on the submission of the government advocate, that's one part of it. He has applied his mind. It is not as though the application of mind is there. I have, in addition to that, raised 5 grounds. So all these grounds, I request, my lords, an opportunity be kindly given. And this statement also against the advocate, my lords, that also pinches us, because in para 26, your lordships were to see the explanation. Page 26.
After 28 years.
We did not know that this part 2004. Of course, if it's a notification, preliminary notification.
83 and 85.
Rooms.
The fact.
Yes.
Land has been acquired, and on acquisition of a land, there is certain consequence, which includes the compensation also.
Please.
No point of time did you approach the court seeking even compensation or challenging?
No. We were never notified. If your lordships were to see, we were never even issued with notice is our case. Notice of PN or FN or whatever it is. And then everything was done by that Anantamurthy only. That's where the original records ought to have been seen. Possession was not disturbed.
When are you required? Are they required to give individual notices when they issue preliminary notification? The final notification.
My lords, they have to be notified and they should be issued notice. The whole proceedings, if we see, individual notices will also have to be issued. And 5A inquiry has to, and we should be given an opportunity to, supposing there are other persons, supposing there is a samadhi, something of that kind, I will plead. Please exclude this portion, exclude this samadhi, this portion. Samadhi is
Post the issuance of final notice or post?
After issuance of preliminary.
after PN, before FN. Now our case is, my lords, 2014, when they came to dispose us, we came to know. It was all done through Anandmurthy only. The records of LAC placed before your lordship and another. I will take your lordships. We did not make Anandmurthy. We did not. If the records are some mallards, I have told my instructing counsel also, being very plain on this issue. If there is power of attorney given by you people, whether they were compelled, forced or whatever it is, then we have no case at all. If amongst list of so many people, if the power of attorney is there, Even your lordship can summon the records and see, my lords. If that is there, it can be closed here itself. If there is power of attorney, we will have no case. They may, I can say that he has forced me to execute the power of attorney, that all will not stand. No, no. This was the second date on which it came, the matter came up. Please, my lords, the first date, that's where, my lords, I'm requesting your lordship to kindly see 26, page 26. Probably that page may be the correct. Page 26, Roman 9.
Including it.
16-1, the case was listed, my lords. Then it was posted to 21. 20th one, which was a Saturday, special sitting day. We have no, I mean, I'm not here to blame, or the court can take. It was a working day. My lords, with all sincerity, my lords, we are not taking any, I mean, objection to the views that's taken by the learned single judge also. We are only before the division bench to see if all these grounds had been taken into consideration, the balance would have tilted this way or that way. I'm asking for only remand of the matter, nothing beyond that. Writ petition, please, my lords. Page 48, my lords, if you are maybe 58, it would be. About GPI, we have taken at para 19, my lords. 18, 19. 17 to 19. Please, my lords.
Just somewhere in the middle.
Hmm.
That the petitioners neither executed GPA in favor.
That the petitioners neither executed GPA in favor of CV Ananthamurthy nor in favor of anybody, and the third respondent, without verifying the documents in proper way, has passed an award by colluding with the fourth respondent society. And para 19 also, we have taken the same contention.
Land acquisition. We are doing the beneficiary under this acquisition.
CIL society, my lords.
Yeah.
Fourth respondent. My lords, it is vacant, and the photographs, even as on this day, if a commissioner goes there, they can see the exact situation like that. It's vacant.
I'm appealing for fifth respondent.
Case of fraud, they are alleging, your lordship, after a lapse of 40 years. They have to approach civil court for adjudication of their right insofar as GPA is concerned.
That you saying that it may be matter be refunded back to the level. For all these things to need to be looked into.
I would even go a step further, my lords. My learned friend may be right. If there is a GPA and I allege that it is fraudulently taken, my case is I have not given GPA at all. So the question of
Yes.
Huh? Government will have the records.
40 years.
It will be their CIL society. They will have all these documents. Land acquisition officer will have.
Lapse of time, your lordship. And possession is also delivered, your lordship. Their own document.
Yeah, what was passed?
Please, nurse.
Who was given the compensation?
Who were given compensation?
Alala, land acquisition officer has given this. Maybe this Anantamurthy Anantamurthy has taken the. Anantamurthy has taken the compensation. This is this annexure J says, my lords, claimant GPA holder is what it says. Annexure J is 130. It is paid. There is a mentioning that it is paid, but who has received it? Your lordship will see in one page. Correct. Kindly see, my lords, the one page that I brought to your lordship's kind attention, 129, 129, handwritten, it is there. ಪ್ರಕರಣವನ್ನು ಅವಾರ್ಡಿಗಾಗಿ ರವಾನಿಸಲಾಗಿದೆ. The ಅವಾರ್ಡ್ಗಾಗಿ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ 13,896. ಅನಂತಮೂರ್ತಿ. CV Anantamurthy is there, man. CV Anantamurthy. He is the person. Everywhere it's there.
Depend upon have you executed anything.
Very true, Manoj. That's all the case. Otherwise, as he learned government advocate said, if we allege anything against CV Anantamurthy that you forced me to execute, I have not executed consent, that's a different case. But if it's a case of no GPA, we fall on a different footing. And award compensation, your lordship asked me one question. Kindly come to 126, my lords. 126 says he has received the compensation.
Acquiring body. For taking place.
Unless this Anantamurthy goes to the extent of telling that he has received the amount from the acquiring body even before the compensation has been received. Kindly see 116, that's 126 probably. Your lordship may kindly say 126. Award. Apportionment is there. Could your lordship lay hands, my lords? Typed copy I'm drawing your lordship's kind attention to. And kindly see, my lords, interest. Since the GPA holder have already received the entire amount of compensation from the acquiring body before taking possession of the land by the special land acquisition, this question of payment of interest does not arise.
Land acquisition officer by land instruction. The R4 is also because lordship kindly see 140, page 140 lordship. Having taken the possession, it was handed over to cooperative society also on the very same.
Take instruction. We want to know how the GPA. This field is so far that challenge to be done. Which respondent you appear for? 1, 2, 3.
1, 2, 3.
Please. The consent was given by one Mr. C.V. Ananthamurthy. Whom the appellant purported to have given a GPA. That's right. Which according to that is not a correct position. Those are GPA has been executed by the appellants in his favor. Support of a submission, but it was made down to the page.
In this case, my lord, I appear for respondent number 4, my lord. My lord, my voice is audible, my lord.
All are,
We can hear you.
all are served with
I
notices.
appear for
Just-
respondent number 4, my lord.
Sure. Just 1 minute. Show the order sheet. Notice has been issued in this.
Please, my lord.
Then you file your objections. Just say that respondents to file their objections. Within how much time? Pardon?
2 weeks.
2 weeks, rejoinder 2 weeks, list on. File your objections, please. Next.
Stay we have sought for, my lords. That
Pardon?
we have sought for stay of this, but anyhow, if status quo is maintained, that would be enough, my lords. Not to precipitate the matter would also be.
Yes, what do you say? On the
Kindly
stay
grant me,
application.
kindly grant me 2 weeks time, my lord, to file my objections, my lord. Kindly grant me 2 weeks time.
Very well. We'll give you 10 days time, file your objections.
Oblige, my lord. Oblige, my lord.
Just 10 days and 10 days for rejoinder. We will look into it after 20. Just give it.
Grateful.
Next.
28-4.
Next. Where is Mr. Raghavan? Where is the boy? Where is the respondent? Huh? Ah, all right. So Beliappa, you have
Yes.
just seen, it was mentioned in the morning.
Yes.
It's basically, he has been put in a de-addiction center. Possibly, that's her case. The married man, possibly the allegations are against the brothers who has forced him to the de-addiction center. So we just take instructions. What are your instructions? There is an FIR also registered.
Yes.
Just see it. What is the progress in that? Just say notice.
FIR is, my lord, earlier once complaint was given.
Pardon?
Earlier also it has happened, that time FIR was given, my lord. Not this time. This time the police took the complaint and they did not, they didn't act on it. Except
No,
giving
but
an acknowledgement.
Why you put in an addiction center like this?
De-addiction center, my lord.
De-addiction center
He's put in-
earlier.
No. Earlier they put in a mental hospital. That is also a private institution. And somehow the wife went with the help of well-wishers, got him released. Again, this time they have broke open their pharmaceutical shop to take over that, took him and put him in de-addiction center. And she has already approached the health department and they have also written a letter. He has refused to take that letter.
Happened to that earlier petition?
Earlier complaint what was given, it's only FIR was done. After that, nothing has happened.
Just check up what happened on that.
Yes. Your lordship could direct the fourth respondent. You can have the alleged detainee present before the court so that his consent could be taken. Or if he is mentally ill, it could be ascertained. As otherwise, these centers cannot take anybody without their consent or on his behalf, nobody can.
It appears to be a private center.
Yes.
Private center, and he's running a pharmaceutical shop. He's mentally sane. I produced even his documents, your lordship may kindly see, page 19, my lord, annexure B.
It is not anybody, for anybody to certify that he is mentally ill.
Yes.
So we will have the same, Lord. So
At the earliest, if he can be got in, because it seems he's been given sedatives now, so that he should not revolt. He's not given access to the wife also, my lord. Wife is present before this honorable court.
We'll have it day after tomorrow. Take your
Yes.
instructions.
Please.
The same Mr. Beliapa appears for respondents on 1, 2, and 3 on advance notice. Okay. You just make inquiries on this 4 also. Day after tomorrow.
Please, God bless you.
should we have him before the court, Lord?
Who,
The detainee?
Yes, yes, let him be present.
let him.
Let him be present before your
yeah,
lordship
be
and-
present. Just say that the husband of the petitioner, namely, what is his name? ma'am?
Subhash Chandra.
Subhash Chandra.
Subhash Chandra,
Yes, ma'am.
MPB, shall be present in the court on the next date of hearing.
God bless you.
All Mr. Raghuvan's-
31. 31.
It's 51. 51. Oh, sorry, I heard 15. Very, very. Your lordship will give me a date on this matter, my lord. Your lordship will give us a date on this matter, my lord. Yes, interim order. Interim arrangement, extend of ex.
Any convenient day to learn at senior, please.
29? Not 28th or 27th, what? 28th. 28th.
It's a Friday, 27.
Friday.
27.
27 of the-
Please,
28th, one, please, very.
Let's-
Interim arrangement weeks.
one information, serial number 30, there was
There's
an
an
interim order
ever-
to be extended.
There is an interim arrangement in this matter which may be extended, madam. 30 hours.
Please. Lady Advocate Ladza, the rent, I deposited 75% of the rent. For that purpose, only the interim order was granted. Please.
51.
Lord, may I request your lordship to kindly see page 109. The directions issued by the learned single.
My lord, pardon. My lord, I'm requesting your lordship to kindly see page 109, my lord. The directions issued by the single judge in the order under appeal.
Yes.
NLSIU is directed to implement directions issued with the Honorable Supreme Court in Nalsa's case by formulating reservation along with measures for providing financial aid to TGs in education before commencement of admission process for the next academic year. Until then, to provide reservation of 0.5%, half the percentage of reservation provided for TGs in employment under state as interim reservation with fee waiver, and for which NLSIU may apply to state central government for appropriate grant. To admit petitioner under interim reservation for TGs, if there is no other TG candidate who seeks or is admitted to third year LLB course for current academic year. In view of the fact that interim reservation is necessitated due to the failure to carry out directions issued by the Honorable Supreme Court in Nalsa's case, admission of TG candidates to third year LLB course in NLSU is in pursuance of this order shall not be treated as excess, even if they are in addition to the admissions under current admission process, as same will be enforced only for current academic year. It would also be appropriate to direct state to take note of claims for reservation for TGs in education also, and formulate reservation and fee reimbursement policy as contained in para 135.3 in Nalsa's case. By this order, the entire administration of the admission process has been disturbed. And this, my lord, is something that I would respectfully submit is beyond the jurisdiction of or the authority of this court, even under Article 226. This is our, my lord, I showed you, Nalsa directions. Your lordship may now look at Nalsa's case, my lord. Nalsa's case. Give me an answer. I mean, there can't be a direction, fee waiver, give reservation. These are all matters of administration to be done by the executive committee. And in fact, this honorable court has taken that view that the executive committee constituted under the NLS Act is the authority to look into all this. Enabling provision. And where do we get this 0.5%? All this completely upsets the, it's not whether it's 0.5% or 1% or, but please be kind enough to turn to Nalsa's judgment. Please see, my lord, 135. Paragraph 135 of Nalsa. My lord, what is relevant, my lord, is 135.3. We direct the center and state governments to take steps to treat them as socially and educationally backward class of citizens and extend all kinds of reservation in cases of admission in education institutions and for public appointments. This direction has been issued to the state government to do it. And in fact, my lord, in Balaji's case, Supreme Court categorically said reservations is a very complex issue. There has to be a complete study. How many people are there? How is the reservation to be done? It's not to be done in this ad hoc manner. And what is the direction issued, my lord? The central and state governments are directed to operate separate, direct the central and state governments to take steps to treat them as socially and educationally backward class of citizens. That is one direction, my lord. And extend all kinds of reservations in cases of admission in education institutions and for public appointments. It is only to take steps to do all this. Then, my lord, what happened in this case was, I'll take your lordship through the list of events that have taken place. We have prepared a note, my lord, which we have also given to your lordships. The position, my lord, was that even Balaji's case, this is what they said. They said steps have to be taken. And then in this case, what happened, my lord, was directions were sought against us. By the orders that had been passed, which I showed to your lordships, the court said, I can't give any such direction. And virtually, so far as we are concerned, writ petitions were closed and dismissed. The court said, I am keeping it alive only to find out from the state government as to what they have done. But now we get an order, issuing directions to us. I showed your lordship those 2 orders. Well, that it was the state to explain, but they have nothing that we know of. No, my lord, no, my lord. I think they have done. I think they have done something, my lord. Huh? But I'm given to understand, my lord, that for public employment they're given 1% reservation, and for education institutions it is still under consideration. 1% they are given. In Karnataka, of course, state government. But this, to say, give them everything free, and I showed your lordships, my lord, when the petitioner applied saying, I'm not able to fund my education, we did give the petitioner some concessions. And petitioner, my lord, has not applied under any other category except the general merit category, and general merit petitioner is not entitled. No. And in fact, my lord, in our notes, we have put all the facts for your lordship's consideration. This is, my lord, completely interfering with the autonomy of the institution by the court. Why 0.5%, my lord? No logic, excepting, okay, 0.5%. My lord, actually, my lord, I don't want to say that there is anything against persons below, my lord. As an institution, especially of an institution of this standing in this country, which has received international recognition, we are not going to take any of, but it can't be done in this ad hoc manner. This request to be done in a scientific manner. In fact, it should, I am not for a moment treating this as an adversarial litigation, but this upsets the entire apple cart. That's the only grievance that we have. And if the state government can be called upon to tell your lordship what is the position, and ultimately the executive committee, my lord, executive council has showed your lordship the statute. It is so well regulated under the statute. And a detailed judgment has been rendered by this court on how the state government cannot interfere. It is all a matter of, on the reservations question, it has to be done by the executive council. So, my lord, this raises an important question of law. Yes. Yes, my lord.
My instructions, your lordship, we are awaiting the opinion of higher education department, lordship. Law department, FD, and welfare department, social welfare department has given opinion on this.
Mr. Rahman is saying in the department, we are reserving for 1%. For education institution is still under consideration.
Please, sir. That is what my instructions are.
Let them come up and tell your lordships what they have done. And then, my lord, what I respectfully submit your lordships, my lord, subject, of course, to what your lordship say. Let them tell us what it is. Then, my lord, on that basis, we will put it before our executive council. And having regard to the all India character of this institution, how to, we are not against anybody. But this has to be done in a proper manner. It can't be done in this ad hoc manner. And petitioner has no right, my lord. Petitioner has no right to ask for admission. My lord, I tell you, lordship, interim order was there by the single judge to take grant admission to the petitioner. We said yes. Of course, we filed an appeal. Appeal was not entertained by this court. And then, my lord, we said, please come and join. Petitioner came. We said, you have to pay the fees. Then, my lord, at that point of time, petitioner said, I don't have money to pay the fee. And then sought to convert this writ petition by filing an application for amendment to say, now from admission grievance, it now became a fee grievance. And then the learned single judge in the 2 orders, it is on record, said, I'm not going to allow all this. This is on outside purview. He didn't get it. He lost it. The petitioner lost it.
My lord, I would have complained at that time. This your lordship may kindly see, my lord. General category. He applied only under general category. Yes, yes. And it would be interim order subject to the final order of this court. If I succeed, the admission will go. Of course, my lord.
My lords, the petition was for 2 years. I've gone through the petition for 2 years, and then I have received this order. The learned senior counsel is not, unfortunately, presenting the entirety of the matter. Every time that he classifies me as only general category without also recording that I applied under the transgender category. My lord, if I may. Yes, sure. Yes. Hmm. Hmm.
Supreme Court appealed to the center and the state government, not in the past. Just hears.
Hmm.
Today, according to the state government, they are in the process, or they are looking into it. But till such time it fructifies as a reservation. They cannot get a reservation till such time they come with a policy. Okay?
If I, yeah,
Just
sure.
It's only till such time the benefit of a transgender is given to you.
Hmm.
Then only the follow would be taken, the follow may possibly do fee concession. Okay. So today, according to Mr. Raghavan, this was as a general candidate, you will given the seat on the basis of the strength of the interim order, which they had implemented because the appellate court had rejected their decision. So once you are given the benefit as a general candidate, your fee that should be on a concession fee would not be applicable. It is like all the results of a general candidate for application of a general candidate would be applicable. What do you have to say?
Lord, that is, most humbly, I must say that that is a wrong understanding of the situation, because the history of transgender rights in the country originates entirely from the Honorable Supreme Court. The 2014 NALSA judgment is the source of our rights, and there is a whole slew of precedents from various high courts. They are essentially making me retry the entire petition, but I will still. From 2014 onwards, we were supposed to have legal recognition in the country, and accordingly, the NALSA judgment said that transgender persons cannot be categorized as male or female and must be categorized as a separate category. And from there, flowing from there, Article 14 to 21 rights have to be granted, including reservation. I will, if I may, I have submitted my memo of authorities. No, my lord, that is a misunderstanding and only a word play on the final directions. If your lordships will kindly look at para 67 to 68 at page 51 of my memo of authorities.
My lord, can I just excuse myself for 5 minutes, my lord, my lord? Great.
TG's para 67, my lord, of NALSA judgment. '51 of, no, page 51 of my memo of authorities. Para 67.
Paragraph 61.
67, page 51. TGs have been systematically denied the right
Yes.
under Article 15(2) that is not to be subjected to any disability, liability, restriction, or condition in regard to access to public places. TGs have also not been afforded special provisions envisaged under Article 15(4) for the advancement of the socially and educationally backward classes of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. State is bound to take some affirmative action for their advancement so that the injustice done to them for centuries could be remedied. TGs are also entitled to enjoy economic, social, cultural, and political rights without discrimination, because forms of discrimination on grounds of gender are violative of fundamental freedoms and human rights. So basically what the NALSA judgment has done is not categorize us in the vertical category of SEBC, but instead to say that we are legally entitled to all protections that are due to SEBCs, but on the horizontal axis of gender. Now, National Law School of India University, as it stands right now, provides vertical and horizontal reservation. Horizontal reservation is granted to disability and women, and not a protected category, but also 25% Karnataka student category. And every time a transgender person applies, that is the only category that will not receive any protection, which is what has happened in my case, where I applied under the transgender category in the general merit. I am not contesting the general merit category. I am saying that I applied in the transgender category under general merit, and without publishing rank list or anything, they summarily denied my admission. I have achieved, so it's not even a question of merit, Your Lordship, because I have achieved much more than the mandated benchmark. The benchmark has been crossed, and even if I suppose I was in the vertical category of SC or ST and I was a transgender person, and if I had crossed the SC ST mandate of 50%, then also I would not have been admitted, because they are not creating the necessary category as separate for transgender persons, which is what the interim order found in. Sorry, no, my lord, because it would be, there is a slew of precedents, my lord, from para 30. Yes. Yes.
If one of those candidates belonging to this category has really cleared the exam within the benchmark and is successful, what can be the ground for them? See, they can't deny it once they don't provide you the benefits under the transgender and deny you the benefits under the general category of SC/ST.
My lord, that is exactly the point of horizontal reservation, which is what the transgender position is, and which is what a lot of precedents have also established, that you cannot put someone who is in the SC/ST category and transgender category as being an SC/ST woman or SC/ST man, because that is how the rank lists and all the procedures are happening. And the moment they do that, they are violating Article 14, 15, 19, and 21, which NALSA, the Honorable Supreme Court. Yes, because we have to be separately categorized. And my lord, as I am standing here right now, I do not have any fundamental right for education in this jurisdiction or any other jurisdiction for that matter, because we are not categorized as per our gender category, which is our right to identity, which the Honorable Supreme Court has granted us, and on the basis of which the Honorable Supreme Court has said that we are legally entitled to reservations as per that category, and because we are, on account of our gender identity, we are backward. My lords, that to just press my point a little bit more, apart from in the impugned order from para 39 to 53, all the relevant precedents where the Honorable High Courts, division benches, single benches have repeatedly granted admission and employment and directed for creation of reservation.
for transgender persons is noted in the impugned order. So at this point, I would not go into that. But on the day of my final hearing, 28th November, Kerala High Court division bench has if you see para 2, 3, and
Not any reservation till such time we complete the policy. Okay.
if I Milords, one second. If I think I'm short on one copy.
I think your copy you're giving.
Everything's.
Oh.
So para 2, 3, and 6, where the division bench of Kerala High Court Honorable Kerala High Court has said that this petition has been filed by transgender persons. While ordinarily this court may not interfere in the policy domain of the government, in cases involving fundamental rights and a clear direction from the apex court existing, the judicial role in enforcing such rights become imperative. The continued inaction by the government, despite clear legal and constitutional obligations, leaves this court with little choice but to consider issuing appropriate directions to ensure compliance with the constitutional and legal mandate. But in this case, the rights of transgender persons have been declared by the apex court as follows, and the directions have been there. No, but para 3, in light of the declaration of law, effectuating measures to protect their rights cannot be said to be a matter that completely falls within the domain of the executive. And this is a special situation for transgender persons in India, and therefore the blanket position that the learned counsel for the appellant university has taken, that no mandamus can be issued for creation of quota or creation of a separate category, does not hold in this case, because our rights flow directly from the Honorable Supreme Court. And Milord, Lord, one. Milord, to answer that question, the fact that the axis of backwardness has been decided, and it has been studied and decided by the Honorable Supreme Court, where all the facts and figures were placed before the Honorable Supreme Court. And so the issue of commission and all of that comes into play does not directly apply in this case, because as in fact, M.R. Balaji also holds that there cannot be, I think in para 18 and 19 of M.R. Balaji, the Honorable Supreme Court holds tells the petitioners that we cannot state that there has to be a set process in stone. The Honorable Supreme Court does not say that, and that it has to be left either to the legislative or executive also cannot be said. And when you read that with the Honorable Supreme Court's position and the fact that transgender rights are coming from the Honorable Supreme Court, and the axis has already been established as gender, and the fact that Master Balachandar also, this Honorable Court has also held that gender-based reservation has to be horizontal. On what basis of proportion of population that disability 5% is being given? Or on what basis, if they have to answer, they are giving. Milord, so for that, Milord, my response is that the response is actually very simple, as I have already placed before you in my objections to the IA and the later objections as well, that there have been studies that have been conducted pursuant to pursuant to the NALSA judgment. The Ministry of State for Ministry of Social Justice and Empowerment had established a expert committee
And based on that, a lot of recommendations, including establishing affirmative actions across the board, came into play. But the state and NHRC came out with studies. Further, organizations like CLPR in Karnataka have also come out with studies. And the problem is that, my lord, if our category is erased from the record, how will data be there? The absence of data is itself our data. If this writ petition had not been filed, there would have been no record that a transgender person participated and cleared the NLSAT LLB 2023, which is what was achieved by the arbitrariness of their admissions process. This is not merely a situation of what category, what percentage of population and so on and so forth. That is not the question at hand here. The question at hand is the arbitrariness and absolute denial of Article 14 to 21. They did, my lord. My lord, if I am appearing in the transgender category, I have to be recorded as a transgender person. The rank list has to be released, and my position in the transgender category has to be shown. And that is the basis on which my admission has to be. Otherwise, what is the principle of equality and equal protection before the law? What is the principle of equal opportunity?
Of the, many seats are there?
120. It would have to be done horizontally, my lord. So they have to explain exactly how they apply their reservation, and accordingly, because it will be an interlocking reservation, and it will be a quota within the vertical. No, my lord. So they have to ideally explain how their reservation works, because in the absence of rank list, we don't know how they are actually implementing it. 120 seats are there, my lord. Horizontally, I wouldn't be able to tell, my lord, because how much is 5% for it will depend on each category, because the vertical, it has to be applied in that percentage.
That's 1%. Something less than one.
Hmm.
Less than one would be the reservation. Then 120 seats you have.
In each category, in each vertical.
It's-
If there is someone who applies in that category, if there is 0.5, they have to.
Still confined to 0.5 in any of these vertical categories. All vertical categories, it will not exceed 0.5 horizontal.
I do not follow. Ma'am.
Let's say there are 10 categories vertical.
Huh.
Horizontal, we have disability, then this transgender would also come.
Yes.
How it works is, whosoever in all the vertical, whosoever is the top of the merit would be given the benefit of disability. Simple, that's the logic.
Hmm.
Okay. Similarly, if you are seeking the benefit of in the vertical, whosoever is the transgender, who is on the top of the merit, will get transgender 0.5 reservation. That's how it works.
Hmm.
See?
Hmm.
Because we are talking of horizontal.
Yes.
You don't deny it has to be horizontal, it cannot be vertical.
Yes.
You will get that benefit.
Yes.
But if there are more than one, if there are more than 0.5,
Hmm.
the moment that quota of 0.5 is achieved, it will stop operating.
Hmm.
Reservation. Or the horizontal reservation.
Yes, my lord. Yes, my lord. But in that category, 0.5, which is. My lord, that is unfair to the transgender person. My lord,
Is vertical. 0.5 in all 10 means how much is the cumulative of it? There are 10 vertical categories, 0.5 in each category, vertical category.
Hmm.
If you add on, means 5%. That means you want 5% of the horizontal reservation must be for transgender. 5% of the total 120 strength,
Hmm.
right? It would be beyond, much beyond 0.5. Much beyond 0.5. It will be, it is 5, means 12, it means almost 5%, more than, less than 5%. Will not be intent. How do we get this 0.5%? The legal single judge says so.
1% is there in the jurisdiction, Karnataka jurisdiction. Of that, half he has extended over. Hmm.
Say that benefit. The direction. 0.5 of what?
Of 1% horizontal. 1% horizontal. The reservation in Karnataka is 1% horizontal reservation.
Person is not for employment.
Yes, my lord.
What the learner single judge says, see, he's conscious.
Huh.
That maybe in employment there, but not in the educational institution.
Hmm.
I will say 0.5% subject to the state government coming with a policy.
My lord, he has also given the 5th direction that says if there is an excess of admissions for that particular year in which this 0.5 operates, they will not be considered as excess. Because basically the arbitrariness of NLSIU, why we should suffer, my lord. My lord,
So no.
I cannot decide for other people. Yes, madam.
Is your understanding of the order of the learned single judge, 0.5% means in each of the vertical reservation? Yes or no?
Yes.
because 1% horizontal. My lord,
Disability, the horizontal.
Hmm.
Does disability reservation says in each of the vertical reservation, disability must be given?
yes,
No.
yes, my lord, that is how horizontal reservation works.
Cumulatively, then horizontal.
No,
Very good, that's our understanding.
no, my lord, that is not, 5% horizontal reservation means 5% in general, 5% in,
What else? What else? Tell us.
what else? My lord?
This is what your submission is, that insofar as learner single judge is concerned,
Hmm.
the author then need to be effective, and whatever benefits will flow on the basis of 0.5% reservation, like, concession in the fees, everything, that need to be given. So submission.
Yes, my lord.
Anything else?
Yes, my lord. I have quite a few submissions. This is the admission notification for this year, 2025-26. This is the second admission notification that they have released since the start of my petition, my lord. My lord, I'm sorry to say that all this technical discussion happened at this point, 0.51% and so on and so forth. They're relevant, no doubt, my lord, but the sum and substance of my petition, my lord, is that, and the outcome of the petition also, my lord, is that NLSIU as of right now, and through the course of my petition, has been found guilty of arbitrariness and violation of Article 14 to 21. And I do not believe that those violations can be resolved entirely on the basis of technicalities, because 11 years have passed since the Nalsa judgment. And I do not see the respondent state better than or NLSIU better than. For me, both of them are equally at fault. And my submission is that, my lord, after the Nalsa judgment, the learned senior counsel may not remember this perhaps, but Nalsa judgment is a judgment in rem. So it will be invoked against them as well. They cannot stand here and say, because at this, as far as Nalsa judgment has not been challenged by anybody, any state authority, but they have not also complied with any part of the substantial aspects of Nalsa judgment. The only recourse that transgender persons have is the Honorable High Courts. And NLSIU for 2 years, when Master Balachandar, they're invoking Master Balachandar, but they are not in line with the Article 14-15 requirements that were placed through Master Balachandar. And they claim that they are voluntarily implementing something. But in 2 years of this petition, where I have substantiated the situation again and again, when the judgment in rem does not require that, it should automatically flow to me. But in every high court of this country, transgender persons are bleeding their lives out to establish the same thing again and again. Consider us as a separate category. Do not mix us in male-female category. Give us the right to self-determination, right to identity, and all the protections that flow from them, because we do not have anything with us. We do not have resources. We do not have inclusion in financial systems. We do not have inclusion in social systems. We do not have inclusion in educational systems, and definitely not in political systems. So, my lord, when your lordship asked me about proportion of population, M.R. Balaji, yes, there is one stand that has been taken, that study has to be conducted. In our case, that study has been conducted by the Honorable Supreme Court, very much in detail. And I have provided the entire judgment through the memo of authorities. And pursuant to that, the Transgender Persons Protection of Rights Act also came in 2013. Yes, my lord. Everything through courts, my lord. Yes, my lord. Most of us have not even crossed the, that, yes, my lord. Yes. 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 So many are there, my lord. Tarika Banu. My lords, may please turn to page once. It was individual persons, so they were given separate category as what happened in the interim order for me. Yes, my lord. Yes. Yes. And even delayed benefit also. Yes, ma'am. Followed with directions for reservations. Yes. Page. Sorry. My lord, the citations start from para 39, page 87 of the writ appeal. So Nalsa is there, Rano is there. Then we have Sumana Pramanik, where the net examination was found to be, UGC net exam was found to be violative for not providing reservation, age relaxation, and fee concession. Para 43, page 89, S. Tarika Banu versus Secretary of Government, 2017, SEC Online. And Tarika Banu was in fact one of the most important judgments, in the sense that even though the where the judgment very clearly stated that not having a separate eligibility criteria for transgender persons is also violative, and to say that because the person has fallen 0.5% below the existing eligibility criteria, you cannot deny the student. Tamil Selvi, my lord, she had to approach the court twice. First for basic nursing, and then again for post-basic nursing, because even though with the basic diploma nursing, the government provided the seat, they, after that, for the next stage, they did not provide. So again, she had to go to court. That is followed by reservations in employment. There are There is also Ruth John Koyala, which is again PG NEET in Telangana, Telangana High Court. If my lord requires, I can provide all the citations once again, or yes, it's all been referred in great detail.
Yes.
Mr. Raghavan would reply, minutes. Just if I may place one aspect, minutes, for your lordship's consideration. In the judgment of the division bench of the Kerala High Court that your lordship's attention was drawn to, the directions are at page 12 are, my lords, to the state government that your lordships did not see. Your lordships would kindly have the judgment, which it appears so, my lords, and further it was a direction to them to take the steps as indicated in that. Please, to take steps. Yes, page 12 of that judgment. In such circumstances, we are of the view that the government shall implement measures to provide reservations for transgender. There was no, my lords, direction for admission or other.
My lord, I provided that submission to point out that the contention of the learned counsel that no mandamus can be issued for creation of quota or for implementing reservation does not apply for transgender persons, as per what the division bench has stated, that it does.
as per the division bench has stated, that it does not flow directly from the executive, it flows from the Supreme Court. Therefore, we can direct that it be done. And in Kerala, in the case of Kerala, my lord, I have last page. Yes, ma'am. In 6 months. And immediately it was done. The backward classes commission has now, but my lord, there is a history to that also, because when my petition began, I had filed the government of Kerala orders, if my lord may see, at 293 and 294, where in based on the representations made by transgender persons, one seat was being reserved. But my lord, in this case, what is NLSIU's position? 2 years of what is NLSIU's position, my lord? 2 years of this petition has passed. There is no doubt that we require reservation. There is no doubt that I have been wrongfully denied. There is no doubt that the financial aid process was entirely arbitrary and only a measure to delay me from enjoying the reliefs of the interim order. None of this is in doubt. All my rights have been taken away. What is the restitution for me?
But the 26th, my lords, I understand Mr. Raghavan's not there until the 26th. After the 26th, my lords, 27th or 28th. Very well.
28th.
Oblige.
My lords,
My lords, keep it at 2:30 minutes. Very well.
my lords, I didn't get the date, my lord. This month. My lords, if I may make one final submission, since my lords asked about the population percentage, which is also a new ground that NLSIU has brought forward. I would just like to refer to Dr. Ambedkar, if I may, because he has made taken a very clear position on the utilization of population as a weightage. The first controversy, I'm reading from States and Minorities. The first controversy relates to the principle of weightage. The majority insists that the minority has no right to representation in excess of the ratio of its population to the total population. Why this rule is insisted upon by the majority, it is difficult to understand. Is it because the majority wants to establish its own claim to population ratio so that it may always remain as a majority and act as a majority? Or is it because of the fact that a minority, no matter how much weightage was given to it, must remain a minority and cannot alter the fact that the majority will always be able to impose its will upon it? My lord, we as transgender persons, we do not have any rights. And because we are not being counted, since 2014 census has also not taken place, I have submitted that studies are not enough. In my statement of objections, I have myself submitted that the studies are not enough. Studies are required. We need to be counted, but we will not be counted unless we are categorized, unless the category is marked and protections are given so that we are not thrown out once we enter the educational institution. That is my submission. Thank you.
Counsel who appears regularly, he's in Delhi, held up, lords. He's not sending me the number. I would only request this, lords, if it can be day after tomorrow, lords, because he had requested. It was his proxy counsel, lords. He had instructed somebody and somebody. He is not answering the calls, lords. Day after tomorrow, lords, my humble request. I understand, lords.
to do it. He has mentioned it and left.
His colleague.
Back
Yes.
to it. We have more concern on that.
In fact, the regular counsel,
Why is there a proxy counsel?
the regular counsel, my lords, who appears, he had sent me a message morning only.
Can inform the court office. It's a consent for tomorrow, day after.
Day after tomorrow, he has given me a consent morning itself, my lords.
After the date has been given.
After the date, my lords, I'm not able to,
Concern of that.
I understand.
We just try. Yes, see, rest we will be just the list.
34, Shri Sunil Kumar. Serial number 34.
Just get it, just get it. I will try. That,
Sir, Mike use me. Sir, Mike use.
Okay, sorry. My lord, need to produce one document, my lord, but it is in Kannada, my lord. Need to translation, my lord.
34, sir, 34. 23-6. Serial number 35. 35.
Appealing for the appeal. If there is a delay of 92 days, we are not in filing the appeal. Next matter.
this issue notice.
24-6. 36. 14%.
I appear for respondent number 1 in this matter, my lord.
Lords, I appear.
I'm appellant, my lord, 14%.
My lord, sir.
I have filed another writ petition, my lord, on the same subject. It may be tagged.
That is,
603 of 24.
Let's add this.
my lords, Lords, one request, my lord. We haven't been served with copy of the appeal papers. I request.
I have filed in the.
No,
registry.
no, my lord. With the registry, the notice, we only got the fine.
No, I will give. Maybe tagged writ petition 13,603. Same subject I have.
We may not be unless and until we have to see it not like this. You want file it, which is the year of that.
2024. Same.
What is the number?
13,603 of.
We don't be here. There's a we don't, I didn't give the date.
19-6.
Oblige.
Serial number 37. Srimati Sumana Naganan.
Yes, ma'am.
I appear on behalf of the appellants, my lords. Our written submissions are ready. With my lord's leave, I'll file it at the registry and any date may be fixed for you. We'll file it in the registry, my lords. I have it ready. We'll file it today in the registry.
My lord.
Please, my lords.
My lords, I appear for the first respondent in these matters.
Yes, ma'am.
My lord, we seek some time to file our objections. Matter may be heard after 2 weeks, my lord. I seek a short accommodation. 24-6. Grateful. 38 urgent, 39, 14%.
Yes. Can I make a humble submission for interim stay, my lord? May appeal, will get it. Who is the other party, third party? What happened thereafter? What happened? Panipat police is calling you? No, my lord. Then? No. Then we'll hear you. Who appears for the respondent number 3?
Mr. Abhishek Marma.
Three served. Three served.
Three served.
Yes.
What you are saying.
My lord, during the court of hearing of the writ petition also, they have not appeared, only on fag end.
They appeared last time, we recollect, they appeared.
They appeared. Somebody appeared. Please.
Yeah, from R3 they are appearing, but
Today
R2,
also they are.
R2, what has happened is, my lord,
Who is R2?
R2 state of Haryana, they were represented by state of Karnataka only, my lord.
R3 is the wife.
R3 is the-
My lord, 7th April. My lord, can I know respondent number 2 and 3?
Please.
For R2 and R3. Based on 7th April. Would allow me to make one humble submission. Tell us on this interim stay, the Supreme Court, the latest order is there. Last week.
Tell us one thing. In what manner they are precipitating this situation? Is anyone seeking your appearance there? In Panipat?
Yeah, my lord, we will have to appear. We are accused, so we have to appear.
Right. Have you filed is there any petition pending in Chandigarh? No.
My lord, proceedings are continuing. Trial is continuing.
Trial is continuing.
Yeah, my
Here.
trial is continuing. Since the stay was vacated, the trial is continuing. It has resumed.
Is there any stay before the learned single judge?
Yes, my lord.
Yes, ma'am.
Stay was there.
Yes.
Yes, my lord. It was there. All along it was there. Only when the judgment was pronounced, all of a sudden the judgment was pronounced like this.
But thereafter they started initiating the trial there.
Yes, they have
After
resumed.
dismissal.
Yes, they have resumed the trial. Because they're having no option when no stay is there.
That's right.
So my lord, this is.
Yes, 1 minute. Do you have a copy of the stay order? Of the learned single judge?
My lord, I have attached it.
To us?
My lord, kindly refer to. Kindly refer to page number 681. Six 81 and 682 lost term. Book 2.
Just read it. What does it say?
Here, petitioner number 1 appearing as party in person through video conferencing. Learned High Court government pleader takes notice for respondent number 1 state. Issue notice to respondent number 2 Haryana State Police to Director General and Inspector General of Police. List of the service of notice to respondent number 2. There shall be interim stay of further investigation in FIR number 50/2021 registered by Baglagunte Police Station, Karnataka, and in FIR number 33/2021 registered by Panipat Police.
Status of the present
Same only, sir, no, this,
Charge sheet has been filed.
same only status, filed only charge, same only, sir, after that only this stay was given, after charge sheet filed.
That is what.
I'm for the private respondent. 3, my lords. My lords, on the maintainability, the writ appeal itself is not maintainable, is my submission. My lords, the fact of the matter is, charge sheet was filed when he filed the FIR, quashing FIR itself. Later on, for the same petition, he made amendment and he challenged the charge sheet itself. Here, the charge sheet was filed way back in, before the single judge, that was brought to the notice of the single judge, and he has produced the charge sheet also.
That is what my humble submission is, that this Supreme Court
Yes,
judgment.
in crime number 33 of 21 minutes. It's gone to, he has taken a long adjournment in May.
Yeah, I had appeared there when he last appeared before this court. Yes, I had appeared.
What is the date now?
Date is now in July.
Right.
Yes, ma'am.
Yes,
Okay, ma'am.
I'm relying on 3 judgments, my lords, previous date also.
And the judgment which he relied was also of Honorable Apex Court, my lord, wherein order of Allahabad High Court was challenged in Supreme Court, not before the division bench. Here, the
40, serial number 40. For appellant, my lord. My lord, today we have filed the paper book before the registry, my lord.
Yes, sir, madam, I have not verified. Madam, this is a matter of 2003 arbitration proceedings. Madam, the arbitrator has decreed in my favor suit for specific performance, 167 acres. And madam, we have paid again as against 4.25 crores, 3.76 crores. And as against 4.25 crores of this consideration amount, we have paid 3.76 crores. Only 49 crores was to be paid. Of course, the arbitrator has awarded that I have to deposit in the, immediately I have deposited immediately after the passing of the award. And this honorable court directed the matter, to keep that amount in the FDs. Right. Continuously it was adjourned, and they have, my learned friend people have taken time and again the filing of the paper book itself. Now also it is incomplete. I am told that.
Morning, my.
Last time also we have.
Yes.
I apologize, my. We are little difficult in getting.
For the submission made on the last day.
We will file the paper book, my lord, before the date, but morning we received the bind, that's the delay, my lord. We are filing, little difficulty in getting the documents.
Don't worry, you will be right also, you have to verify whether it's.
Actually, we received.
You know,
the
morning what
documents
happened?
from Sir's office only. my lord.
I'm sorry, to make a submission, morning, some of our colleague had came to our office. And while serving the copy, he mentioned that the exhibits were not part of this paper book. It is not.
No, exhibits.
That's what your colleague only said. No, I think it is filed in the court. You can check up here only in the paper book.
File the paper book, my lord, it may be.
Has been filed during the registry. The same is not for the applicant, the same is done.
7-4.
Please. Great.
41, Ajit. 41.
For respond.
$42.
I pay for respond 1, 2, 3.
Just having some.
4-6. 43 urgent. 46. 46. Fourth of April, sir. 48, 4th of April. 4th April, sir. 48.
Appear for the respondent, my lord, seeking a time for adjournment. Adjournment. Adjournment.
Time permit to file the Millard compliance memo, registry Millard. In fact, I complied the Millard, the interim order passed. Will file. Interim order may be extended. Please, my lord, we complied the order petition. Interim order may be.
49, 22-4. 22-4.
Please.
Serial number 49.
I filed application for release of the amount, my lord. 50 lakh is deposited by the Yes.
Twenty-two, 4. 50.
In this case, I filed in a memo, my lord, with regard to the disposal of the case for this reason, my lord, the learned single judge's order was accepted in respect of the one respondent. So it is the in respect of payment of compensation by way of consent award, my lord, that was sought for. The learned judge has, by impugned order, set aside the award, passed general award, and passed a fresh award in accordance with the new act. The learned friend is also agreeing in our discussion, said, my lord, if the direction is taken away, then they will accept the request for 29-2, my lord, for consent award. That's the reason I filed a memo. He was here from disposal. I stated why I was seeking for. There are two this thing, my lord. One is payment by passing a general award, payment of compensation under the KIDB Act. Another is by way of consent. Now, actually, general award was passed under the old act. That was challenged by the respondent. Then, my lord, the learned single judge held that, my lord, the award passed under the old act is incorrect. That is set aside, and the fresh award is to be passed in accordance with the new act. That is what the demand was made. Then, my lord, an application was in fact earlier also made. Apparent Mr. Gopala B is appearing. It was here. Kindly have, my lord, Monday, next Monday, my lord, because there's emergency. Payment of compensation, my lord.
Yes. I would request my lords to kindly read this day after tomorrow.
We can take it. And then early meeting. File it tomorrow morning. Mention it, we'll get a list.
Very good.
So it should. Okay.
I see.
We appreciate you over this. We have to follow that process.
Very good.
Okay, file it early meeting.
Tomorrow itself.
Give a copy to the others.
I'm
submission. 26. Serial number 26.
Serial number 16.
This matter pertains to delegation of powers to Assistant Commissioner. Delegation of power to the Assistant Commissioner. Serial number 16, my lord. The conversion is conversion of Chandrasekhar.
Six, 3. 26, serial number 26.
First responding.
Applying for applying my lord. Senior as personal inconvenience. Kindly have it on 24/6.
Yes, madam.
24, 3. Serial number 29.
For appellant. Police morning session, I could not appear. Yes. In this case, my lord, appeal by the defendant, my lord. My lord, the case of the respondent is, my lord, the present appellant received a sum of rupees, my lord, 29, my lord.
Please, lordship, kindly, but serial number 50 may kindly, but short date. Tomorrow.
24.
24, I'm not in stage 2.